Court officer.
Ready, sir.
Sitting ideal my lords. Sitting ideal.
There, sir.
Okay, yes, my lords. Thank you, madam.
ಗೊತ್ತಿಲ್ಲ ನೀವು ವೇಟ್ ಮಾಡಿ ಸಬ್ಮಿಷನ್
ಇವರನ್ನ ಕಂಡಸ್ ರಜೆ ಇದೆ ಅಲ್ಲಿ ಎಷ್ಟರ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಎಂಟ್ರಿ ಮಾಡೋರಿಗೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಾ ಇದೀವಿ ರಿಜಿಸ್ಟರ್ ಐ ಆಮ್ ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಅಲ್ಲ ಅದೇ ಎಂಟ್ರಿ ಮಾಡೋರಿಗೆ ಕೇಳ್ತಾನೆ
ನಾವು ಹಾಕಲ್ಲ, ಅದು ಮೇಡಮ್ ಸ್ಪೆಸಿಫಿಕ್ ಇದ್ದಾರೆ. ಮೇಡಮ್ ಸ್ಪೆಸಿಫಿಕ್ ಇದ್ದಾರೆ, ನಾವು ಹಂಗೆಲ್ಲ ಹಾಕಕ್ಕಾಗಲ್ಲ. ಯಾರು appeal ಆಗಿದ್ದಾರೆ ಅವ್ರನ್ನ ಹಾಕ್ತೀವಿ. ಹೇಳಿ. ಅದೇ ಗೊತ್ತಾಯ್ತು ಮೇಡಮ್, ಇವಾಗ ನಾಟ್ ಅಟೆಂಡೆಡ್ ಆಗಂತಂತೆ. ಹೇಳಿ, ನಾವು ಕೋರ್ಟಲ್ಲಿ ನಾವು ಅದೇ ಕರೆಕ್ಟ್ ಮೇಡಮ್. ನೀವು
ಇಲ್ಲ.
ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್, ಮಾಡ್ಕೊಳ್ಳಿ. ನಾವು ಅವ್ರಿಗೆ ಹೇಳಿ ಹೇಳಿ ಸಾಕಾಗಿದೆ. ಅವರು ನಾವು ವಿ ಆರ್ ಎಕ್ಸಾಸ್ಟೆಡ್. ನಾವು ತೋರಿಸ್ಬಿಟ್ಟಿದೀವಿ ಸರ್. ನೀವು ಇದ್ರಿ, ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸ್ಬಿಟ್ವಿ ನಾವು. ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಿದೆ ನಿಮಗೆ. ಅಲ್ಲಲ್ಲ, ನಾವೇನ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಇಲ್ಲಾಂದ್ರೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ, ನಾವು ಅಟೆಂಡ್ ಆಗಿಲ್ಲ ಅಂತ.
म्यूजिक नहीं है, बीस हाईकोर्ट इसी में हूँ। 10:45 अभी तक जजेस नहीं आया।
स्टार्टिंग टाइम क्या है सर?
10:30।
10:30 को हाई कोर्ट में। सीट पे कॉल मारते हो ನೀವು
गाड़ी
Yes. Out of the list?
Memo of posting.
What is that?
My Lordship, we filed for February. Till the date, we are not getting a posting. This is the fourth time we are posting, My Lordship.
Which year is the writ petition?
4859, 2026.
It is never listed.
Yes, ma'am.
Find out, take that why it is not listed. Yes. Out of the list.
My lord, there's a repetition filed against a private bank. There's an interim stay against us.
Take that.
Filing an application to revoke stay.
My Lords, it's a pending matter, my Lords.
Hmm?
It's a pending matter.
Which year?
My Lords, 2024, my Lords.
Oh.
My Lords, in the previous hearing, the Honorable Court has been observed that the case has to be dismissed, my Lords. Even after that, statement of the objections has been given time to file a statement of objections. Kindly,
No, some other date must have been given. When is it?
No, date is not been given.
Why the date will not be given?
No, adjourn for a week, my Lords. After that, my matter has not been.
Take that. As for the convenience of the court, yes.
Your Lordship, this is 2023 tender matter. We have for the respondent number 2, we have to file fresh tender notification. The petition there's a vacant, there's a interim order granted. We have filed vacating.
How you understand, how it has become urgent at
Your
today,
Honor, we
just
filed
before
for
vacation? Huh?
IA for vacating stay, we filed it in the year 11 to 2025. It's not.
Take it, yes.
One matter, for your Lordship, kindly see. The duty and penalty order passed by the Deputy Commissioner question before this court. In respect of the suit of the year 2008, I filed an application for impleading. Due to the pendency of the writ petition, the suit is not moving. Therefore, I am filing an application, memo for any date may be fixed.
We'll see. Yes.
My lords, the writ petition is of 2023, my lords. It's relating to electricity matter. The connectivity issue has been stalled, my lords. The petitioner has obtained interim order and has not complied with the office objections. We have moved this honorable court on the earlier occasion. It was listed before the registered because petitioners have not complied with the office objections. It's been 3 years they have not complied with the office objections. Kindly have it on 21st, my lords.
But in one matter, your Lordship had given date for today, my lord, to file a party affidavit. Party is present before the court, matter is not listed.
Why?
Order sheet is there, my lord,
Why
along with the
date
memo.
given matter is not listed? 2:30, yes.
Please.
Unregistered lessee is trying to stall the RC proceedings before the DRT, my lords. He has filed a writ petition. He claims to be an unregistered leaseholder of the property.
Which year is that?
25 months. RC proceedings, I'm at the stage of
What
issuing
I'm not able to
attachment.
understand is why all these became so urgent just before, a week before
No,
vacation.
my lords, I had moved it earlier, my lords. It was not listed.
We'll give all those memos to the court officer whenever it is convenient to the court.
withdraw the
If it is convenient to the court, it will be listed. Yes.
Withdraw the petition already.
Yes, tomorrow. Yes.
The memo is filed.
Huh?
ಎರಡು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ ಆದ್ರೂ ಬರ್ತಾ ಇಲ್ಲ ಕಂಟಿನ್ಯೂ ಟುಡೇ
Listed tomorrow. Yes.
My lord, the memo is filed with the respondent bank. The petitioner is got the interim order, but he is not complied.
Take it.
You have filed the interim order.
Yes.
Lordship, memo for being spoken to on
Yes,
the last
tomorrow.
date,
Give it
interim
to
order
the
was
court
not.
officer.
Petition became
Yes.
infectious, my lord.
Huh?
Become infectious, my lord.
Yes, tomorrow. Yes.
My lord, it is a matter of 21, my lord. There is a stay and I'm moving the memo and we have filed the objection also long back. It is not coming before the court, my lord.
The court also has to do all this, no? Give it to the court officer as per the, give all those memos to the court officer as per the convenience we'll take up. Yes, call the list.
My lords. Lords, may I mention?
Page-wise adjournment, list number 1, page number 4, serial number 11 to 15, page number 5, serial number 16 to 18, page number 6, page 19 to 22, page number 7, 23 to 29.
25 million.
25.
Yeah, after vacation.
Why?
Advocate has gone to US.
Advocate?
Has gone to America, some urgent.
Yes, sir. 25 matter, not even notice is ordered.
He had to go, that's why.
No, no, we'll at least order notice. Why should it be pending without a notice? We will see. Yes.
Page number 8, serial number 30 to 36, page number 9, 37 to 38,
My lords,
page number 10,
My lords,
page
page
number 10, 39, 38.
my lords, serial number 39. I beg to appear for the
Yes.
petitioner. I pray for a week's time, your ladyship.
Who has
been
moved the
led-
memo?
I believe the respondents counsel has moved the memo.
Then we will not grant time. You please wait till the matter is called. Yes, next.
Page
Well,
number
they-
11,
they-
41 to 47.
Yes.
42, my lordship, I'm offering for petitioner, the advocate and record, father is in hospital, so that I just after vacation.
What is this 42?
My lord, this is, my lord, 2013 incident, my lord. Now they are seeking for investigate the matter, my lord. C report is filed in the year 2013. That has not been challenged anywhere, my lord.
Let this matter at the request of the land counsel, the petitioner on 21st, no further time. Yes, next.
Page number 12. Till number 48 to 52. Page number 13, 53 to 58. Page 14, 59 to 64.
My lords, may serial number 59, my lords, appearing for petitioner, my lords.
Adjournment, my lord.
My lords, counsel is unwell, my lords. Request for 21st, my lords. On Tuesday, we'll argue.
See the order sheet, my lord.
21st, my lords.
No further adjournments will be granted.
My lords, counsel is unwell today, my lords. 21st, we'll argue, my lords.
That's what happens if you keep on asking time like this when you're not, and you're unwell also, others will.
My lords, Tuesday we'll.
Yes, Tuesday, on that day, if adjournment is sought, the writ petition will be dismissed.
My lords, interim order may kindly be.
Yes, interim order will be continued, and it's not just an order, I'll dismiss it if you ask for
Please,
adjournment. Yes.
Lord, serial number 48, my lords, I appear for the petitioner. My lords, on the last date, your lordship had directed us to produce the translated copy of annexes. All annexes are in Kannada. My lords, we are ready to receive it. We'll receive it tomorrow. May I request your lordship for Tuesday, my lords?
Without translation, I'll pass orders.
My lords, may I request
Not
for
required. Yes.
Tuesday, my lord?
Page
No.
number 15, cell number 65 to 68. Dismissal letters. Number 2, number 1, cell number 1 to 3.
Lord, serial number 18, serial number 83. Today ask me to file affidavit, my lord. Party has not come due to some inconvenience.
3
Kindly-
is for dismissal. I will not hear at the time of mentioning. I will only hear it when the matter reaches. Yes.
My lord, serial number 45.
Take that.
Serial number 182, my lordship.
It's one, wait.
List 182, my lordship, adjourned for 2:31.
Made a mention, court is passing order. You're supposed to wait.
My lord, cause list number 2, serial number 1, my lord.
A memo is filed stating that the writ petition has become infructuous on account of the respondent executing the sale deed by issuing the sale certificate in favor of the auction purchaser during the pendency of the above petition. Hence, the writ petition may be dismissed as withdrawn. A memo is taken on record and the petition is dismissed as withdrawn. Yes.
List number 182, my lordship. Serial number 82, adjourned for 2:30, my lordship.
Why?
Today we go for the,
I've already said the matters which are in dismissal, they will not be heard at the time of mentions. You have to wait till your matter reaches. Yes, next.
much of.
Serial number 45, my lord.
How many times the court will go front and back? Wait. Yes, call the list.
My lords, once there's a correction in the order, my lords. The matter was directed to be listed yesterday. Instead of 30 days, it is written 20 days in the order.
It is not listed in spite of a specific order.
It was directed to be listed
There
yesterday.
is are they there? Why it is not listed? When the memo is given, it should come. Let it come tomorrow. Call the list.
List number 1 for being spoken to, serial number 1, Murthy K.
Yes.
I am for the respondent 9.
This is matter for further hearing. This court has passed an order on so-and-so. Looking at the latest judgments of the Supreme Court, this matter requires hearing. Hence, the order dated so-and-so is recalled. There's this matter for being spoken to for further hearing on 23rd.
Cell number 2,
Any other date, ma'am?
23rd.
Any other date, ma'am? 23rd?
New one.
23rd, okay, ma'am. Much of
Serial number 2, my lord. For the petitioner, my lord. Matter was allowed on 2/4. This matter was allowed by your lordship on 2nd
Senior
April.
citizen.
Yes, my lord.
No, in this what
is-
happened is.
Yes, my lord.
You have wrongly shown the age as 59 years, but it is not so.
We have
No,
the ration card, my
Come
lord.
come to the petition.
Yes, my
That's
lord.
fine. He's 64 years old.
That is his contention. In the records, it is 59, my
How
lord.
can that be? How
His
is-
ration card we have. I can
That you
place it.
can't, you cannot show something else, what is not there before the authority. Cost title will be produced as it is. Is it
Yes,
not?
my lord.
Look at the cost title before the authority.
Yes, my lord. One.
It is shown Basava Shetty as 66 years, but in the writ petition, my lord, it is shown as a 59 years.
That's
Because
what
we
looking
had
at
his-
it, I said it is not, he's not a senior citizen.
We had
And
his
how
ID
did the-
card, my
How
lord.
did the registry number it?
Registry, maybe, my lord.
They
Because
shouldn't
we
have
had the
done it.
ID, we had placed. I'm sorry, my lord. I'll convince your
This
lordship.
court. This court has passed an order on, when is the date?
2nd April, my lord.
2nd April.
Yes, yes, ma'am.
2nd April, by allowing the writ petition and the reasons to follow, as it is submitted that the respondent is not a senior citizen as on the date the application is filed. While dictating the order, the court found that the date of the respondent is 60
years,
or 68?
66, my lord.
I'll just give
66
the
years-
ration card, my lord.
66 years old as on the date of the filing of the application. Land counsel for the petitioner submits that as per the ration card is 59. That aspect.
Election ID, my lord. I'm
Election
sorry.
ID is 59 years.
Yes.
This aspect was never raised before before the authority.
It was
No.
raised, my lord. It is there in my evidence, my lord. It was
Ah,
raised.
Before there is no finding
On
that.
record, my lord.
But you can't on your own change the cost title.
I'm sorry, my lord. It was an
Uh,
inadvertent because of this.
It is, what did you say?
There's no finding to that effect. That is right, my lord. I will concede.
The cost
No,
title
delete
15
that.
years is shown.
When the cost title before
59 years is shown.
before the authority shows his age as 66. And in the cost title that's before the court, it's shown as 59 years. Hence the court, as he is not a senior citizen, has allowed the petition. Now looking at the age of the petition, the respondent, this matter requires hearing. This matter for further hearing on 23rd. And the earlier order is recalled.
Sale number 3.
Obliged.
For orders matter, sale number 3. Sandhya Jamdagni.
The list after service of notice.
Sale number 4. Sale number 4, CH-17.
My lord, my lord, the memo,
That, where is the memo?
my lords, memo for withdrawal.
I think already you filed.
No, my lords.
You're filing it now. Take that.
Lord, since the petitioner is residing out of the country, he has sent
The
an
memo is
email
filed,
which we have.
stating that the petition is not interested to prosecute the matter. Accordingly, memo is taken on record and dismissed as withdrawn. Is filed.
Sale number 5. Sale number 5. Raghu HP.
Yes.
The respondent, ma'am. This request for a passover, my lord. Senior counsel is on his
Yes,
legs.
passover.
Much okay.
Yes, next.
Sale number 6.
I appear for the petitioner in this matter.
Yes.
In this matter, my lord, charge sheet is filed, my lord.
Huh?
Charge sheet is filed, my lord,
Let's see what is the relief that is sought. Give the file.
to act on the complaint. Page 19, my lord.
Yes, they have filed the charge sheet. Nothing remains for consideration.
I'm told they have filed my lords, but
Now it is before a year
Petition
before.
is filed seeking the following prayer. Learned HCGP submits that the police have conducted the investigation, filed the charge sheet.
Well, on the complaint, my lord, FIR is registered in crime number 138 of 23.
What is it? You can tell the CC number, that's fine.
CC number 58288 of 24.
58288
Of 24.
24 on the file of
29th ACJM Mayall.
29th ACJM,
Mayall Court.
Mayor.
Mayall, Bangalore.
Considering the fact that, or the relief that is sought in the writ petition is already worked out. Nothing remains for consideration in the light of the charge sheet that's filed with the respondents. The writ petition is disposed of. Yes, 7.
Malats, I beg to appear for the petitioners, Malats. Malats, on the last
Appearing for
occasion,
the
we have filed a statement of objections, Malats. The rejoinder is ready, Malats. I'll file it in the counter, Malats. Kindly get 2 days time for me to.
What is this matter about?
My lord, they claim that they have paid the entire dues. They claim that they have paid the entire dues, but then, but my lord, they have paid as per the interim order of DRT. But then there is unapplied interest which they have to pay. And so they have, so we have, there's a claim of about 22 lakhs.
Let the rejoinder be filed. We'll dispose it of.
Yes, my lord, let
It
them
is
serve a
submitted.
copy.
The petitioner seeks time to file the rejoinder. This is matter on 25th. No further time.
Lord, I've already served a copy of the objections. It may be taken as the complied, my lord.
The respondent counsel has already
Served the copy of the objections on the
objections from the
petition.
counsel for the respondent. Yes, next.
Please, ma'am.
Appearing for the petitioner, my lord. Petitioner is a tenant or the property, scheduled property. Respondent
Come to the
on
prayer.
Yes, ma'am.
You are questioned the possession notice dated 6/8/2024. On what ground?
Lease agreement is a registered lease agreement,
Huh?
my lord. Registered lease
Is the
agreement,
lease?
page number 18 to 20.
Date.
Date. Oh, 24/2024. The before issuance of demand notice.
24.
2024, 2024, my lord.
When is the mortgage?
My lord, much before that.
Demand notice is 7/5/2024. You don't know
When is the
the
mortgage?
My lord, Lord, this is a very same petitioner. One more petition has been filed before this honorable court, and this honorable court disposed of date 20. Mortgage legal. And given liberty to my lord,
Collected matter.
DRT within 1 month time. Mortgage.
Why another writ petition is filed?
No, there are two schedule in a same premises. In fact, property sold, so auction purchase, similar sale certificate issued, everything is over. And this honorable court given 30 days time to go before the DRT. My lord, in this matter also same order can be.
This property is not sold actually.
Huh?
This property is not sold.
Even if it is not sold also, 13(4) will not go into all that. The writ petition is filed, seeking the following prayer. It's a case of the petitioner that he has a registered lease deed dated 24/2024, and the bank has issued the possession notice without following the procedure. When counsel appearing for the respondent, bank submits that in respect of the in respect of other property pertaining to the same borrower, correct?
Please, my lord, please, my lord.
Borrower, another writ petition is filed, WP number 6769 of 2025, that came to be disposed of by order dated 24th February 2026, giving liberty to the petitioner therein to avail the appropriate remedy before the DRT within 30 days from the date of receipt of the order. It is submitted that in this case, the petitioner has questioned the 13(4) notice, as he has an effective alternative remedy. All these disputes can be raised before the DRT. In that view, having heard the counsels on either side, considering the fact that the other connected writ petition is already disposed of, giving liberty to the petitioner to avail the appropriate remedy. This court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to approach the DRT. Petitioner shall have the benefit of Section 14 of the Surface Act, Section 14 of the Limitation Act, and the petitioner shall approach the DRT within 30 days from the date of receipt of the copy of the order.
4 weeks stay may be granted. 4 weeks stay may be granted.
Stay is already there.
Only for disposition it is there.
Question concern.
The stay shall operate for a period of 30 days.
Number
Yes.
9, Srikanth M for petitioner.
The stay shall operate till the time granted by this court expires to approach the DRT. Yes.
For petitioner,
9.
kindly pass it over, my lord, senior counsel.
Pass over.
My lord, it's a
Auction purchaser notice is not
sale
yet served.
certificate SL before this honorable court. Earlier rounds of litigation, my lord, wherein in fact we pointed out.
Anyhow, let him have let the senior counsel argue same order, we can pass in the afternoon also. Yes, 10.
Number 10, M.A. Rajendra.
If respondent, my lord. Senior is in DRAT, they will receive tomorrow, possible. My lord, 3 times they have done the same.
Have your senior told you to make such a submission? Will anybody submit that he is in DRT? That's why I
DRAT.
put wherever it is.
This case has to go to DRT only. DRT order is assailed.
Take this also there.
For condemnation of delay, it can.
Your senior is there, let him argue this matter there in DRT.
It has to go to DRT only. DRT order is assailed here.
This is matter at the request of counsel to petitioner on 23rd, no further time.
24th, my lord.
24th? Yes, 24th. Yes, Nick.
Cell number 11, giving on application.
I am appearing for the appellant, my lord.
Hmm.
Notice may kindly be added to the LRs of the deceased, my lord.
Notice is not required. IA may be allowed. I will file wakalat for respond number LR of the respond number on today itself, my lord.
The IA number 1026 is filed to bring the LRs of the deceased R1. Land counsel Venkatesh R. Bhagat submits that he has instructions to appear on behalf of the LRs. IA number 1026 is ordered. I ordered and consequently and IA number 2 of 26, which is filed to condone the delay of 543 days in filing the LR application, is also allowed. And the 3 of 26 is allowed by setting aside the abatement. The petitioner shall take the land counsel, the appellant shall carry out the necessary amendment to the cost title.
Please.
Yes, admit post of final hearing.
Much obliged, man.
All for the TCR. TCR is already there. Just admit post of final hearing. Yes,
Cell
12.
number 12.
Last occasion, notice has been ordered.
I
on
represent
IA
the respondent.
condemnation of delay.
Yes, my lord.
No objections has been filed.
Well,
On
in this
IA,
case-
notice has been ordered. Condemnation of delay.
Only one respondent?
Yes, please. Only one respondent.
Let's
Only
hear. Where is-
37
where is
days.
the order?
Yes, my lord. They are challenging the review petition by filing a review, questioning the order of this honorable court, my lord.
That's what we'll see. Where is the order? What is the review?
Yes, sir.
Yes, argue.
And actually, A is the order of this honorable court, my
Yes.
lords. I'm only pointing out, my lords, this order has been passed on 4th September 2025.
Hmm.
My lords, the question is, the wife is getting maintenance in two cases simultaneously under Domestic Violence Act and also Criminal Proceedings 125. And this court, my lords, already held that on 13th January 2025, well before this order. On similar circumstances, this court has taken a view that wife cannot maintain in both cases. My lords, I will read page number 23.
That issue will not arise when the RPFC is filed before this court, questioning an order passed by the court, when such a contentions are not raised. Some judgment somewhere in some other case passed will not apply to this.
Although here also, she is
Let
getting,
us see what is your contention. I must record it. What is your contention?
my lords,
Let's see.
page number 18, my lords.
Yes. Page number 18.
18, para number 4 of your lordship's order.
Hmm.
Learned counsel appearing for the petitioner has been submit that wife is not entitled to claim simultaneous maintenance under different acts. It is
Need
submitted
relief
that
under section 12 of the Domestic Violence Act. It is in addition to all other reliefs you have.
regarding maintenance,
Maintenance only I'm saying. It's
Yeah.
like whatever the reliefs you have under section 12 of section under the Domestic Violence Act itself is clear.
your lords kindly see page number 23. This court held that.
Hmm.
Already this court has taken the view.
What is he dealing with?
23,
Uh,
23, para number 2 itself onwards. Entire thing is, my lords.
Yes.
Learned counsel for the petitioner would submit that. Respondent having already obtained an order under section.
If you
so
have
and
any
so.
order of the Supreme Court, you please show. I will not follow this order.
My lord, Supreme Court also held that.
Where is
Rogers, this court followed by Supreme Court order.
Let's see that. Which
Page
is-
number 25, my lords.
Where
This
is the
court-
judgment?
Page number 25, it has been referred.
Please give the judgment. Give that the copy in Rajesh versus Neha.
Yes.
That was referring to 125 CRPC and under section 24. It never said about the Domestic Violence Act because the act itself is clear. No judgment would be contrary to the statute. Let's see.
Referring very same judgment, this court has taken the your lordships also referred to the same judgment. This court also have to.
That's not the way. You have to tell the court, show the judgment, not because somebody has referred it, when he has referred to a judgment of the apex court in
Same,
Rajneeshwar.
same facts and circumstances only.
Mr. Counsel,
Very same facts.
you have to, first of all, have you read the judgment of Rajneesh versus Neha? Have you read?
Yeah, Millards may taken up after some 10 minutes.
That's without
After
even
vacation.
doing minimum work. You just file a review petition.
I filed revision petition. Millards, this court has taken the view,
Who's-
referring the.
I have not taken the view.
Yes.
If you are relying on a Supreme Court judgment, basing on a coordinate bench issue, my order will not be changed. And when you're saying that, the coordinate bench has has referred to the judgment of Rajneesh versus Neha. At least the minimum work would have been, anybody who has to do, look at Rajneesh versus Neha. What did Rajneesh versus Neha say?
First have some after vacation.
My submission is
Password.
Millards.
After vacation, Millards.
My submission
No.
is
Any other day.
No,
Today
no,
we
no.
are having some busy.
Millards, they have to pay 25 lakhs, Millards. They have not paid even 1 rupee.
I'll not grant. I'll dispose it of today itself.
Yes, please.
Password. Yes, 13.
Number 13, MRC Manohar.
Or else
Appearing
Millards,
for
Tuesday,
the respondent, my lord.
Millards, may
Appear
first and
for
Tuesday,
time,
Millards.
my lord.
Why?
My lord, I'm not keeping well and I'm yet to file my objections, my lord. Kindly, it may be taken on next week, my lord. I have some medical emergency in my home.
This matter next week. Yes, next.
Please.
Then number 14,
In this case, I appear for the applicant. The writ petition was dismissed for non-prosecution on 17/1/2025. And the council.
When did you
actually-
file the petition? When did you file the IA?
IA is filed recently, that is on that 24th March. The council actually, who was representing earlier, he is not in the country. He has gone abroad and he is living there. And he has not informed the petitioner herein about the pendency or dismissal of the writ petition. Lord, and the petitioner was unwell.
Argue the matter on the merits. We'll
Yes,
hear it
yes,
and-
my lord. Yes, my lord. He
Yes.
has a very good case on merits. The lordship may kindly see
Who appears to the respondent?
government and
My lord,
C. Jagdish.
My lordship, I am appearing for respondent, my lordship. Copy of the writ petition not served on us, my lordship, in spite of the order dated 2/12/25, my lordship. Kindly direct the petitioner council copy served on us.
I will serve the copy, but actually the council on record is no longer there. Is not in the case. I will serve the copy.
Serve the copy. When you serve the copy, I'll recall the order.
My name may
This is
kindly
not
be shown,
after
my lord.
vacation.
My name may kindly be shown in the cause list,
When did you file wakalat?
or on 24th March.
Look at it. So and so submissiary has filed wakalat. The registry shall reflect the name. This is matter after vacation.
cell number
My
15,
lord, urgency is there because the police are after the petitioner. It may be taken up next week, my lord.
Why were you not, why have you not served?
No,
papers on
I was
that?
not the council earlier, my lord.
This
Recently, I-
matter on 23rd. By the date, if the papers are served on the council for the respondent,
Yes.
then only the matter will be heard. Or is that IA filed for recalling the order dated 17/1/2025 will be dismissed on that ground.
please.
Yes, 15.
cell number
So
15,
respondent, it was my say, my lords. Now, this is a matter where the challenge may cause the constitutional validity of an enactment.
Sir, one second. My lords, we've engaged the senior counsel, Mr. KG Raghavan. He's on his way. May we kindly pass over, my lords.
May I make a submission? Lord? This is the third time same things
How
happen.
many times?
I'll make
What
my
are the-
submissions. I'll make my.
If you engage the senior has to come when the matter is called.
Yes,
Every matter where everybody engages the senior, we can't pass over. Court has a work.
understand, my lords, but he's arguing a matter in court hall 7.
Obliged.
Pass over.
Obliged.
No, this has become a routine practice. We engage a senior, pass over. Why senior can't come when the matter is called?
cell number 16, Subramanya Bhatt, a petitioner.
Lord, in this case,
Evaluate.
I appear for the petitioner.
Yes.
Lord, what is under challenge is, my Lord, Annexure G at page 69, my Lord, which is a provisional assessment order, my Lord, proposing to impose back billing charges on me. My Lord, no doubt, my Lord, I have got an alternative remedy, my Lord, of preferring an appeal under the Electricity Act, under section 126 of the Electricity Act, my Lord. This petitioner has not preferred any appeal, but as far as the other relief, my Lord, which have been sought in the writ petitions, are that, my Lord, at page 10, my Lord, prayers 1 and 2, my Lord, on account of passage of time, my lord, they may not be surviving. So as far as prayer number 3 is concerned, my lord, your lordship may be kind enough to grant me the liberty to file a statutory appeal, my lord. With that,
It is appealable, not an appealable order. First, they have to file objections to that Annexure G.
We'll
Lord,
give
with
them
that-
a liberty.
Very well.
That liberty to file objections before the assessing officer. The authorized officer, as I have stated in that para 6 of my statement of objections.
Yes.
My lord, petition, kindly pass on, senior in.
Who is he arguing?
My lord, I have filed wakalat, my lord, after obtaining NOC.
The present writ petition is filed, seeking the following prayer. It's a case of the petitioner that he has entered into a joint development agreement with one Asadullah Khan and others on 27/8/2016. In respect of the property bearing number 584 5th Cross, 6th B Main, 3rd Block, Koramangala, Bangalore. The said Asadullah Khan also executed a general power of attorney in favor of the petitioner on 27/8/2016. Pursuant to which the petitioner applied for the sanction plan to the BBMP and the same is sanctioned. And the petitioner has put up the construction. In the meanwhile, the said Asadullah Khan has raised dispute before the arbitrator, that is in AC number 82 of 2021 and CMP number 20 of 2019. Because of the dispute and COVID-19, work has been stopped and the petitioner was not using any electricity, and in this regard, petitioner paid minimum electricity bill every month by renewing the same. He has paid the same up to September 2021. In this regard, the petitioner submitted a representation requesting the respondents to sanction fridge connection to the building. When the respondents have failed to take any steps, petitioner has issued a legal notice on 5/20/22. With regard to the inflated back building, and now calling upon them to take the suitable steps and to consider his representation dated 4/12/2021. After issuance of the legal notice, 2 police personnel came to the house of the second petitioner on 7/1/2022 and took him along with them to the Goripalya police station. But they have not taken him inside the police station. From there, they have taken the second petitioner to Koramangala police station and insisted to him to get the electrical contractor and also the first petitioner and beaten him very badly and caused injuries over the body. Thereafter, they have forced the second petitioner to direct the contractor and the first petitioner to withdraw the complaint lodged for the managing director of BESCOM and also to the vigilance with regard to the legal notice issued to them. And they bring him back to the house, and from there the petitioner was taken to the hospital. After that, the petitioner had lodged a complaint to respondent number 1 to 5 with regard to the torture given to the electrical contractor. Now you're seeking the relief against whom?
Now, my lord, prayer 1 and 2, my lord, is by way of a mandamus directing, my lord, the respondents 1 to 5 to consider my representation. My lord, they are my lord, 1 to 5. 3, 1 is the state, 2 is the chairperson, Human Rights Commission.
Your entire grievance is against the police.
Yes, my lord. So, my lord, my submission is, my submission is over a passage of time, my lord, these prayers 1 and 2, my lord, may not survive for consideration. Now, what has happened is, by virtue of an interim order passed in this writ petition, my lord, I had deposited 50% of the back billing amount and my lord, power is restored. So therefore, my lord, and since my lord, Annexure G is only a provisional order.
They agreed with the action of the police and also the inaction on the part of the respondent number
6 and 7.
6 and 7. The petition is before this court. Then counsel appearing for the petitioner submits that as far as reliefs 1, 2 are concerned, by reflex of time, the petitioner, such prayers do not survive a consultation at this point of time. As far as 3 is concerned, he has an alternative remedy and there may be a liberty granted to the petitioner to avail the appropriate remedy. Then counsel appearing for the respondent number
5 to 7.
6 and 7.
5 to 7.
5 is inspector of police.
Oh, sorry, but 6 and 7.
6 and 7 submits that that is not an appealable order.
That is in a provisional
Once-
demand that they have to file objections.
Once the bill is raised, if the petitioner has any objections, he has to make objections before which respondent?
Authorized officer. Not that.
Before the
Authorized.
authorized officer, but there is no provision of appeal. It is submitted that with the petitioner without doing all this exercise has come before this court in 2022 and obtained an interim order. Learned CGP submits that as the petitioner has not pressing for the reliefs 1 and 2, for whom the against the respondent 1 to 5. The writ petition may be dismissed as far as the release against the police are concerned. Next matter, having heard the counsels on either side, there is a material on record. When according to the petitioner, the respondents have given the bill, the bills, the amount that is raised as per the bills is not correct. The remedy that is available to the petitioner is to raise his objections before the authorized officer, but not filing an appeal. And as far as the reliefs against the police are concerned, as the petitioner is not pressing for the same, the reliefs, the prayers 1 and 2 are dismissed as not pressed. And as far as the relief 3 is concerned, the petitioner shall file his objections within 1 month from today before the authorized officer, and the authorized officer shall pass appropriate orders. And in the light of the same, even prayer number 4 also, prayer number 4, no orders needs to be passed on prayer number 4 accordingly disposed of.
Cell number 17,
Yes.
Lata Shetty, petitioner.
Proposal had to be given, my lord. My instructions are, my lord, the parties have met with the bank officials. Proposal talks are going on, my lord. A settlement.
Negotiations are going on.
My lord,
Negotiations are going on.
please, my lord. Negotiations are
Is it
going on.
correct?
Maybe, my lord, what had happened, my lord, this honorable court directed me because 2 property we have sold, 1 property is left. And my lord, they assailed before the DRT and my lord, that they suffered an order. And 1 property, in respect of 1 property, they are aged people and all. This honorable court directed me to, my lord, consider the representation.
Whether the negotiations are going on
That,
or
my lord,
not.
I have to take an
If
instruction.
not, we will take up the matter.
No, I have to take an instruction on that effect.
When you want.
My lord, tomorrow, definitely, any day, my lord, because
This matter
there is.
on 25th of.
I'll make it only one thing, my lord, clarify before this honorable. This honorable court directed me on, my lord, 11/3/2026, stating.
All waste of time,
Great.
25th April.
Great.
By the time we get instructions, if not, we will proceed it on the merits of the matter. Yes.
Cell number 18, Venkat Somareddy,
Yes.
petitioner.
My lords, in this matter,
What is this report received from additional CJ and JMFC? There is a report. Have you brought this? Where is your counsel for the petitioner in this? What is called is 18? You are called 18. Somebody is representing it. Oh, just now I've seen somebody representing. Password. You can sit, I'll call you whenever. Yes. Next.
Cell number 19.
My lord, I am appearing for the respondent in this matter.
What is this
my lord.
extension of time?
My lord, they had to pay
So you're
on.
representing in the next case. That's why I was wondering.
Sorry,
I saw,
Sorry,
I saw the advocate, and by the time I have complete reading the file, advocate is missing.
Lord, in this matter, my lord, they had to pay, we had given the OTS
So what is this
facility.
extension of time?
Now, they had to pay on or before 28 to 2026. They have not paid single rupee also, my lord. Now they
They have
want
to pay
extension.
on or before 28 to 2026.
2026. They have not paid.
How much they have to pay?
1 crore 81 lakhs. They have not paid anything. Now they have come for the extension of the time, my lord.
I
On
think if
that
I
we have
remember
to
on the
take-
last occasion.
Yes,
I
my lord,
said,
your lordship directed me to
as
find
per-
out. On that, they have to take a call, my lord. Your lordship may kindly have it next week, my lord. I'll, by then-
And counsel for the petitioner submits that as per the one-time settlement, he has to pay the amount by 28 to 2026. As they could not pool the funds, they could not pay the amount, hence filed an application before this court seeking extension of time. And he is ready to pay the amount. On the last occasion, this court has directed the land counsel appearing for the respondent bank to find out whether it is feasible for the bank to accept the amount with interest till date. On this, in this regard, land counsel for the bank submits that she requires some more time. This is matter on?
My lord, Wednesday, my lord, Monday.
This is a matter on Wednesday.
How less?
Yes, next.
Cell number 20. Cell number 20. Devraj, Devtej.
My lord, as ordered by this honorable court, he paid that amount, 8 lakhs and all, my lord. But the next payment, only that. 8 lakhs, this as ordered by this honorable court, that petitioner paid 8 lakhs. So that next payment, this honorable court has to order, because earlier I filed on, bank has filed an affidavit as an.
Outstanding amount as of now.
As of now, 47 lakhs, 77,000. 47 lakhs, 77,000 as on date, after adjusting entire amount.
Yes,
May I make my submission? Madam?
yes.
This respondent bank, the respondent bank is a nationalized bank, my lord. They are extending the facility of one-time settlement according to their website and all the other kind of notifications issued by them. I am a poor agriculturist. To construct a house, I borrowed 28 lakhs rupees. Out of 28 lakhs rupees, 16 lakhs rupees I had paid when I was in service. Now I am retired and I have not received my pensionary benefits. With much difficulty, I have paid now 23 lakhs rupees. So
Is a one-time settlement scheme
No, my lord.
available? Huh?
One-time settlement, it is not there. That is.
it is
They
very
sent
much.
the letter also, they sent, there is no one-time settlement, this amount has to be paid. And this writ petition is filed challenging the demand notice as well question notice.
No, my lord,
That's
my
all.
submission is only this.
OTS is not there.
One-time settlement, if at all it is not there, let the bank manager file an affidavit, then I will take
Why
it up.
should he file an affidavit?
No, my lord, in their website, they have said that there is a
No,
one-time
that is
settlement.
not what you saw, what you have questioned before
No, no,
this
it is
court.
not a question of, it is a bread and butter of one poor farmer, my lord. He has borrowed 28 lakhs rupees, he has paid 36 lakhs rupees, the bank is extended, it's a nationalized bank. Bank is extending the facilities of one-time settlement to all the farmers are getting. Article 14 is applicable to me also, this is a constitutional court. 26 lakhs rupees is not a small money. Now they are saying it is 47 lakhs rupees. How I can pay it? Should I sell my property and live in a road?
You ask yourself.
No, it is not my
It's not
question.
fair to
I am
court
asking
to
the
tell
other
you.
side. I am not
So you pose a
confronting.
question to yourself,
No,
not to
I
the
am not
court.
confronting with the court. I am just asking the court.
And
They have got a website. In the
I
website.
do not,
No, your
I
lordship.
can hear the argument even if you are not so loud, Mr. Senior Counsel.
No, my lord, I am not loud. I am.
Loud. You are loud, you are shouting.
Okay. No,
Yes.
but the moment they dispute whatever is displayed by them in the website, any person will get emotional.
Not the council.
You know, it is not a question, my
Not
lord.
the council. But party may be emotional, council need not be
My lord,
emotional.
see, one-time settlement OTS scheme for agriculture, retail and other segment borrower limited.
Where
period
is
of-
the IA? Where is the IA seeking one-time settlement? Where is the relief? Without that, picking some paper from the website and placing it before
on
the
the-
court
on-
will
in
not
the-
give
in
you
the-
any
in the-
relief.
In the month of March,
Where is the, no, please understand, Mr.
Please,
Senior Counsel.
Please,
You have filed a writ petition with some prayer
please.
and you want something else.
Yes.
You can't across the bar say something and the court will not consider it. And this is not the way how it goes.
I will file it tomorrow itself.
What you will file it tomorrow?
File an IA for.
You come up
No.
with, you come up with an affidavit before this court.
My lord, this.
Whether the petition is entitled for a one-time settlement or not. Only one simple sentence. That would suffice.
Yes, I'll file.
I will pass the remaining will be taken care of by the court.
Please, Bill.
Does this matter? And there should be reasonable submissions, Mr. Senior Counsel. You come to the court with a prayer. Whatever is the prayer you're entitled, court will give. If you are seeking some other prayer, it should be by way of an application known to law. But you cannot say about the emotional aspect,
On the
emotional things.
last occasion, my friend said, if I pay 8,50,000 rupees, they will consider OTS.
No,
I deposited that
The
money.
land counsel for the petitioner submits that. The OTS scheme is in force. Land counsel for the respondent bank shall get specific instructions. The land counsel for the petitioner has argued stating that it is a hard-earned money of an agriculturist. He has paid a hard-earned money of the agriculturist when it is violative of Article 14, when on the website shows that they are offering a one-time settlement, there should be equality. All these kind of submissions, this court cannot consider. This court is concerned with what is a prayer before the court, whether it is reasonable, whether it can be granted within the four corners of law. If the petitioner wants any relief, that should be supported by, there should be a prayer and a supported documents before this court. Anyhow, considering the submission of the learned counsel, the respondent bank shall get, a counsel appearing for the respondent bank shall get specific instructions by the next date of hearing, whether there is any OTS proposal available, whether the petitioner is entitled for any is eligible for the OTS scheme. If the answer of the bank is yes, the matter will be heard on that basis, or else the counsel appearing for the petitioner shall address the arguments on the merits of it. No further argument on this aspect on the next date of hearing. List this matter
My lord.
on 27th of April.
My lord, only one submission, my lord.
Yes,
In our objection statement, it is clearly mentioned, he submitted the OTS, OT was considered and rejected.
that is what I'm asking you now. Just take a piece of paper to say that. Get the same thing, you address a letter to your bank, whatever your bank says, place it before me.
Right.
That's
Yes,
sufficient.
madam. Yes, madam.
Yes.
Interim order may be extended.
Interim order is extended, and on the next occasion, if no further arguments on this OTS proposal, if the bank is not, if the petitioner is not eligible, matter has to be heard on the merits. Yes.
Cell number 21, Kalyanar for petitioner. Vignesh Shetty.
My lord, the respondents had undertaken that they will file the statement of objections.
I'm appearing for the
File
respondent.
statement of
Finally,
objections.
week's time is granted for filing objections. No further time will be granted. You're ready?
No, my lords, we have already given the draft of objections to the bank for for their validation.
I
and the
have not
approval.
said the draft should be sent by the next date of hearing.
No, my
After
lords.
that, you will take time. I will pass orders on, no, let everybody understand that it's not, you can't take the courts for granted. Writ petition of 2025, when is it filed? On 23/10/2025. And you keep on asking for time for filing objections.
My lords,
There won't be any, yes, no representation on behalf of Mr. Suresh HS.
I am for R.
Huh?
R2, I am for the R2.
Who is R2?
The bank, SBI Bank.
Suresh HS is who is appearing for whom? Respondent number one is who?
One is Union of,
For R2 and 2. Yes, Satish.
Union of India,
Union of India is a.
the
formal
State
party.
Bank of India. Yes, what is the writ petition
Contest-
about?
Who is contesting?
You argue the matter, I'll dispose it of.
Lord,
Your lordship, we had given it, like, it's been a
That's not
week,
the
my
problem
lord.
of the court. Yes,
my lord, in this case, my lord, the petitioner is challenging, my lord, the sales certificate issued.
Kindly pass over at least, my lord, please.
list this matter. Finally, on 24th.
Please.
If on the day, on any reason, the adjournment is sought by the respondents, the writ petition will be allowed with cause.
Great.
Cell number
Much
22, Kalimullah Sharif for petitioner. 22.
You the file. This is a writ petition filed in the year 2023. So far, notice is not even ordered to the respondents. When the matter came up today, there is no representation on behalf of the petitioner. List this matter for dismissal tomorrow. Yes, 23.
23. Girish Srinath.
That's I appear for the respondent bank, notes. That's my instructions are that the accounts have been regularized, notes, so nothing.
Regularized. Land counsel, there is no representation on behalf of the counsel for the petitioner. Land counsel appearing for the respondent bank submits that the account is regularized. Hence, in the light of the submission, that the submission made with this respondent is taken on record and the petition is disposed of in the light of the submission.
Number 24. Purna Chandra.
For the petitions, my lords, I'm filing a memo for retirement in this case.
Lord,
Lords, I am appearing
your
for
lordship
the.
may kindly see the order sheet.
I know that.
Please.
This order, it's already reflected.
There is an alternative remedy of
In
appeal
the
under
cause
section
list
20.
itself,
my
it is
lord.
mentioned that no further adjournments will be granted.
Yes.
In the morning session, Passover is sought. Again, in the afternoon session, it is stated that the senior counsel is engaged and again seeks Passover. This court cannot adjourn the matters in this fashion. Finally, this is matter on 16/4. On that day, this court will not grant any Passover or adjournment, and either of it is sought, the writ petition will be dismissed on the ground. So either of it you will not ask, you will, now you're coming up with
Retirement.
My lords, I'm appearing for the petitioner. I'm taking over the matter.
let's see what is that you have stated in that retirement memo. So this is the original is with you.
My lords, a copy is given.
When you have given, so he is aware of it.
My lords,
Nothing.
I received instructions
To
only in the
appear.
morning.
Yes, argue.
No, my lords, 2 weeks time may be
No,
granted.
I'll not grant time. You come up, you argue this matter.
No, my lords,
on
I just
21st.
received instructions in the morning, at least
21st, I will not grant more than that.
22nd, my lords.
Yes, 22nd. It is submitted, the counsel, Mr. Puna, so-and-so, is permitted to, a memo is filed, is permitted to retire from the case. So-and-so submits that, right on your, he has instructions to file wakalat. Registry is directed to print his name. List this matter on 23rd. No further time will be granted. And if the adjournment is sought, the petition will be dismissed on the ground. Is 25?
Number 25.
I represent petition counsel.
Balakumar.
It's some inconvenience for the advocate.
I don't know what is the purpose of filing the writ petitions
No,
and keeping it pending
If I had the
without even a
papers-
notice to the bank, nothing.
I'm sorry, my lord, I could not. He has to advance.
Yes, Canara Bank, who appears?
Some emergent notice may kindly be issued at that.
Is here.
Here, let him take.
The so-and-so
I
is
lost the
directed to take
hot-
notice
Sandeep.
for the respondent bank. The counsel for the petitions is how the copy of the writ petition is this matter after vacation. Yes, 26?
26. 26 PM Nanja Reddy.
Last occasion, Your Lordship,
Yes,
my lords, sale did not take place for the want of bidders, my lord.
it could not take place. And what is that is sought in the writ petition?
Position, auction and also, my lord, one-time settlement.
Questioning, so the writ prayer number 1 has become infructuous.
Yes,
Sandeep.
And this court cannot grant.
yes, my lord.
Please come, the writ petition is filed seeking the following prayer. Extract the prayer, land counsel appearing for the respondent bank submits that because, for the want of bidders, the auction dated, they could not proceed with the auction dated 10/2/2026. Hence, the writ petition has become infructuous. Next para, land counsel appearing for the petitioner submits that they see the another direction, another prayer that they sought before this court as seeking a direction to adhere to the OTA scheme offered by it. And there may be a direction to the respondent bank to provide a OTS to consider the case of the petitioner under the OTA for the one-time settlement. Next, para, having heard the counsels on either
It
side.
will be
for the
open for
material
the-
on record. Huh?
It would be open for the bank.
If it is, why you give a representation? As far as the prayer number 1 is concerned, as the auction could not take place, nothing survives for consideration in this writ petition as far as prayer number 1A is concerned. Then coming to the prayer number B, this court, there cannot be a mandamus to the bank to provide the one-time settlement scheme. If the one-time settlement OTS scheme is available, if the petitioner is at liberty to make his representation, and the respondent bank shall consider the same in accordance with the law.
Yes, my lord.
Yes, next.
Number 27 Dhananjay Kumar.
Your Lordship, I'm appearing for the petitioner. Your Lordship had directed us to correct the prayer. There is a slight mistake in the prayer, my lords. Instead of OA, we have mentioned it as OS. And Your Lordship had directed us to make the correction, but the branch refused to give the file for many times.
Yeah, that you can do. Now you come to the point. What is it?
Your Lordship, we will do the correction before this court. Kindly pass over, because the matter is posted for
I will
judgment
hear
tomorrow,
it
my
right
lords.
now. Then you can make the correction. You are ready?
My lords,
Pass over. Give him the file to make the correction.
much.
So
Yes,
number
next.
28.
This case appear for the petitioner, my lord. I challenged the sale notice dated 9/3/2026. The date of auction was 26 March 2026.
C. Subramanieswara Cooperative Bank. The writ petition is filed, seeing the following relief. The respondent is Subramanieswara Cooperative Bank Limited in the light of the law laid down in so-and-so, so-and-so. In the light of the law laid down in Vishwabharati's case, the writ petition against the respondent is not maintainable. Accordingly, writ petition disposed of, giving liberty to the petitioner to avail the appropriate remedy. The petitioner shall have the benefit of section 14 of the Limitation Act. Yes.
29.
Avail the appropriate remedy within 30 days from the date of receipt of the copy of the order. Yes.
29.
Respondent in the bill.
Chair for the petitioner, please, my lord.
at least time 2 weeks in my, I file my necessary objection. 2 weeks time, please.
Please, my lord.
My
This
necessary
is
objection.
the petitioner appellants, sir, petitioner have obtained a loan in the year 2018, please, my lord. The amount of is 15 lakhs, please, my lord. Thereafter, they issued a notice. We have given a reply to that notice. They are not ready to furnish the details, please, my lord. We are ready to settle the issue. Whatever the balance amount is there.
What is
we
the
are-
prayer? Come to the prayer, let's see.
Please, my lord. Issued it as an annexure dated issued by the respondent.
Issues,
taking the
issued
position of-
dated.
Now they are issuing the, trying to taking the position, please, my lord. That's it. We are already filed the dispute before the joint registrar, please, my lord. We are seeking for the particulars. We are ready to pay the amount, whatever the balance amount is there. But they are not ready to furnish the accounts and.
When did you tell them that you are ready to pay the money and you want the particulars?
In the year 2020 itself, please, my lord, I have given a reply as a notice, issued a notice to the respondent bank, please, my lord. That is an annexure F, please, my lord.
Page number?
Page number 33.
33? So basing on a notice issued in 2020, you will come before the court in 2026.
But they have issued a notice on recently, please, my lord, in the year 2026.
When was the 13-2 notice is issued?
13-2, they are not issued the 13-2 notice, please, my lord.
Proceedings are under the Surface Act.
Please, my lord.
The proceedings are initiated under the Surface Act.
Not at that,
So how come you filed a petition which is numbered as this?
But they are.
Jurisdiction also.
Huh?
There is no jurisdiction, you challenge only in DRT.
But the, your lordship, is the annexure A, please, my lord.
Let us see, where is that, what is the impugned notice? Where is
Notice,
it?
please, my lord. There, your attention to the invite.
Which number?
Your attention to page number 17, please, my lord. Last paragraph. Your attention to invite to the provision of section 13(8) of the Act and respect of the time available in the to remedy in the secured assets. Please, my lord. Then you are advised to.
Is a demand notice dated, then you have to give your, give your reply to this. How can you come to the court?
But they are not ready to talk with the approach to the bank. Only thing is.
Don't approach the bank.
Yes.
When you have received a notice on 12/2/2026, what are you supposed to do?
Yes, with liberty to, I will give a notice, then
Huh?
till the, I will give a reply to this notice, please, my lord. Till then, not to precipitate this matter, please. my lord. Now there is.
For that you have to come to the High Court.
No, even otherwise your lordship may kindly see, I have filed a dispute.
I'll not see anything else. When a notice is issued under 13(2), why you have not replied? It's the first question.
13, not issued 13(2), please, my lord.
This is a notice under 13(2), Mr. Counsel. This
13 to
12/2,
notice dated in
2023.
12/2/2026.
Yes. Not on 32, that their approach to the bank and come and negotiate with the
They have
bank.
given to you a notice on 23/9/2025 under section 13(2) of the Act. What you
That I have issued a reply to that notice.
Where is it? Where is it? Show.
That not, please. Yes, your page number 86, please, my lord.
Page number?
86.
What did you say?
This is legal notice.
To the 83, our reply is 86, please.
Does he think that it is a legal notice?
Please.
What is this para number 1, para number? No, whatever is your objection to that, you are supposed to say. What is your objection?
That is an, I given a reply to that 32 notice, please, my lord.
I'm sorry, Mr. Counsel, if you're not understanding what the court is asking, this is matter after vacation. Yes.
30. Cell number 30.
In this matter, I am the petitioner, Your Honor. Your Honor, here I have challenged I am the action purchaser, Your Honor. The bank has issued the forfeiture letter without considering my requisition letter to extend the time to grant to pay the balance amount. Your Lordship kindly
How
peruse
they are obligated to give you extension?
Your Honor, as per the provision of Rule 9 subclass 4 clearly stated that in case
the action purchaser given a rating, the bank has to be extended up to 90 days.
When was the sale? When was the auction?
Action is held on 16th, Your Honor. Sorry, Your Honor. 27/2, Your Honor.
May I submit?
7/2,
Yes.
2026.
I am permitted to take notice on behalf of the respondent bank. The auction was held on 27/2/26.
Yes.
And in the sale confirmation letter, we had made it very clear.
When is the date, sale confirmation?
Sale
Here,
confirmation
2nd March 2026.
2nd March, yes. As per that, when he has to pay the money?
On or before 16th March. Now,
16th March.
while giving the
Then-
sale confirmation letter, we have made it very clear that in terms of Rule 9(5) of the SARFAESI, in default of the payment within the period mentioned, the deposit shall be forfeited,
No.
property shall be resold.
Under the rules, if they make a requisition, if some 45 days or something, some extension is.
90 days is there.
Under the, it is there, extension, the provision is there, but
When there is when there is a provision and when you can extend the time, why you don't? Why should you?
But even now, my lord, he has
Why
not
should you
come
be so
forward with the
rigid?
payment. His only request is that I will pay. That's all. When he will pay, no timeline is fixed. Nothing is there in
I
this.
have mentioned
No,
your,
let him know whatever it is, whatever time is and no, how much money has to be paid?
I have paid 13,25,000, Your Honor.
39 lakh 70,000 is required to be paid. 39 lakh 70,000.
39 lakh
70,000
is that to be paid?
is to be paid.
When are you going to pay this?
Within 4 weeks, I will deposit that amount, Your Honor.
4 weeks.
Yes,
When
sir.
is that 4 weeks means?
4 weeks, next month to 15th, Your Honor.
Hmm?
Next month, on or before next month, 15th, Your Honor.
What is today?
Today's 15th.
16. You will pay by 15th of May.
Yes, sir.
15th of May would be like how much time? From 16th March. Then what are you doing? 16th March, that is 16th April.
Put it 1.5.
2 months, that is
2 months.
60 days, which is permissible as per the rules.
But the
No, whether it is
competent-
permissible
yes,
or not.
there is discretion vested with the
That's what,
competent
how
authority.
much is the time? 60 days is permissible?
This is permissible.
So we'll give him the time.
But I'll
If
take
he
instruction.
doesn't,
May
if
kindly
he
be taken
doesn't
up
by the
tomorrow.
time, no, if he doesn't pay the amount by the time, whatever has to follow will follow.
Then is that the time of, when the auction was made very clear, he is required to pay within the stipulated period. Initial payment was made, second payment was made within the stipulated period. Third payment, that is the final balance of sale consideration, has taken time. It is not a regular borrower, my lord. He is a real estate agent.
Whatever it is, you have conducted the auction. What is the, no, how the bank is benefited by cancelling auction, calling for another auction? He's ready to pay. Now what you're giving is only a matter of a month's time. Give it. If he doesn't, you forfeit the
I'll take
amount.
it, I'll kindly take up on Tuesday. I'll take instructions
Yes.
from the bank.
Please indicate, please tell your client that this is what is
Already,
indicated by the
I
court.
personally visited, requested the bank
Copy of the
official. Your
request.
Honor.
Anyhow, list the matter
Copy
on.
of the petition may kindly be served on.
Please, sir, today itself I can.
Mr. So-and-so submits studies instructions to file wakalat. The registry is directed to show his name in the cause list. The counsel for the petition saw the copy of the writ petition today itself on the
Yes, sir.
counsel. When do you want?
On Wednesday.
Wednesday? List on Wednesday? Yes, 31?
Case number 31.
Same for the petition. In this case, for respondent number 4, this first respondent had mortgaged the apartment in favor of the petitioner. We have simple mortgage. Apartment plot number G01.
You know, what is the relief that you're seeking?
In the same apartment,
One minute. To direct the fourth respondent bank not to initiate, continue any proceedings under the Surface Act.
yes,
Prohibitory injunction, prohibiting them, alienating, creating the encumbrance. What are the facts?
that's this, as per annexure A.
When
This
did you
first
purchase the
respondent
property?
who was the owner of the property, had mortgaged for 40 lakhs. That is on 18/5/2019. The same apartment being a fictitious number, he has executed a sale deed in favor of respondent 2 and 3. And they have taken a loan from the respondent
2
number
and
4.
3, when was it sold?
This is on 19/10/2019.
registered memo was executed. Now,
They have taken the loan from which bank?
the fourth,
Indian Overseas Bank.
Indian Overseas
No,
Bank.
both the loans are from the same bank.
No, well, we have not taken in the loan.
No.
We,
First respondent.
who
first
was the
respondent,
owner of the apartment?
Both the same bank.
No, he's the
No.
owner of the property.
Fourth respondent.
First respondent has mortgaged the property and taken loan of 40 lakhs, is what he said.
First and respondent is the owner, second and third respondent is the purchasers,
Purchase.
fourth respondent is the bank.
That I understand. What he's submitting is first respondent has mortgaged the property,
Yes.
No.
taken 40 lakhs loan.
40
on
lakhs
80
from the petitioner.
From the,
Petitioner.
Petitioner is the lender.
has executed a registered mortgage in your
Yes,
favor.
Ministry page 17.
Hmm.
Now this property, when it was mortgaged, by giving a fictitious number as GF01, he has sold to the respondent 2 and 3. And they have availed a loan from this respondent for Indian Overseas Bank. They have committed a default in payment of the amount. So the bank took the possession of the flat which was mortgaged to the petitioner, under the pretext that this is the one which has been mortgaged. Though the flat number GF01, there is no such flat at all in the apartment building. And he is the habit of executing similar double.
But how this court will decide all this now?
That's what you can see in respect of very first respondent, Annexure F, page 74.
Oh, correct. Assuming that first respondent is has indulged in these kind of acts.
Yes.
What will this court, how the court will determine this property is not the property which is mortgaged to you, or these two properties are one and the same or different?
That exercise this court may not, but the fact remains is, you kindly take the judgment of this honorable court, page 74. Similar, the first respondent in the same year, in the same building, there are 2 apartments which were earlier sold, was given renumbered and sold to the parties there. And this honorable court has considered that aspect.
What is this? The petitions are allowed quashing the impugned notice, declaring the bank cooperative banks cannot have recourse to the Surface
Yes.
Act unless there is clear vindication of its charge in
Now,
the property.
Apartment has been, simple mortgage has been executed for 40 lakhs, it has been registered. Now the owner, by tilting the apartment number, executed sale at bank without due diligence and without proper verification, advanced the loan. And now take the position of the apartment which has been mortgaged to.
That's
Yes.
what precisely I'm saying.
Yes.
According to you, there is only one property, showing it as 2 properties, 2 mortgages are made by the owner.
Yes.
One to you, the other one to, he sold the property and they in turn had taken the money from the bank.
Yes. Yes.
Now, how can this court say that the properties are one and the same? They are not 2 different properties.
No,
And how will this judgment come to your rescue?
No, similar apartment here, just let me kindly see, page number 78. Apartment number 03 plus 301, it was earlier sold. Subsequently, he has executed a sale deed in respect of this very apartment as GF03. And bank had advanced the loan. When the bank has issued a notice, the petitioners in that petition have challenged it before this honorable court. And this has taken note of this, para 4 of the.
I can't, but I'll not pass an order of this kind.
Page number 80, para 4.
Those disputed questions of fact, there can't be a finding by this court.
No, what this honorable court has not given finding with reference
No,
to the
it
sale deed.
has- it
This
said
is
that-
what this honorable court has held.
Impugned notices are set aside.
Yes, sir.
How can it be set aside?
No, unless bank establishes clear vindication of its charge over the property which was mortgaged to the petitioner by the owner before executing the sale deed. That is what this honorable court has held now.
But why should we say that there is no proper verification? Even according to you, the number, what the number that is, the plot, the flat that is mortgaged in your favor, and the plot that is mortgaged in their favor contains 2 different numbers.
Number is different, but the same apartment, which was, there was a charge in respect of the same
We
apartment.
can't give those
which-
kind of
which
findings.
cannot-
And I can't interfere with the.
No, this judgment where this very first respondent is a party, the same apartment building. It is not something other apartment or the same. Now, para 4 also kindly see.
I have seen that judgment, but I can't.
Page number
I can't
80,
pass an
para
order of
4.
that nature. I can't.
Para 4 of the,
I've seen that. I've seen that. What is the description? What is the analysis? But this court cannot. This is this court cannot enter into that domain at all.
no, the fact remains is the bank, which is an institution.
Then both of you fight it out. You fight it out against the bank, against them. You seek the declaration of your title to the property.
No, I am not entitled to take, only I am concerned with my money which is secured through a
Or
simple
whatever it
mortgage.
is, but
And
recovery of
whatever
money you
that the
are-
bank has now done is subject to my charge. Because prior to the mortgage only, I had the simple mortgage registered in respect of
You take a
apartment.
chance relying on that judgment after vacation, but I'll not interfere. After vacation.
Meantime, I'll file wakalat and objection.
Yes, next.
Then number 32.
I appear for petitioner, madam. Madam, challenging the sale notice issued by the madam first respondent, madam. And admittedly, madam, I'm not claiming any right over the secured assets. And also, madam, I'm not against the SARFAESI proceedings. The only issue is with this with madam. During the process of identifying and marking the properties, madam, instead of marking the land belonging to the respondent number 2, they have shown their land in my survey number, madam. That is the only dispute. With respect to that is concerned, my lord, Annexure F, my lord, survey report issued by the surveyor, my lords. Annexure F.
How can all these fall under the disputes raising of under
Since,
the
my lord, there is
Surface
a-
Act and the DRT? How can this be numbered as a DRT?
No, my lord. To relegate the issue under section 17 of the Act, my lords, I have to claim a right over the secured assets or, my lords, I have filed a case against the SARFAESI proceedings. But in the case at hand, there is a only issue with respect to identification and marking of the boundaries. They have shown, my lords, that their property in the property where my property is situated. That is the only issue. Even, my lord, there is a bar under section 34 to relegate the issue before the civil court.
What is the relief you're seeking? To quash the sale notice?
Please, my lords.
Hmm.
And second relief is
Hold an
concerned-
auction to the property bearing number in which actual portion of the interest so and so.
Instead of, my lord, marking the boundaries where the respondent number 2 has been in possession, they have shown the my property in the place of their survey number. That is the only issue.
Who are you?
I'm the adjacent landowner, my lords.
When is the sale going to be affected?
My lords, 23/4 action is fixed. 23/4 gave. If they have proceeded in terms of the, my lords, that impugn survey report, my lords, I will lose my possession. Though, my lords, I am nowhere concerned with respect to the SARFAESI proceedings.
The petitioner it is submitted, the petitioner is a third party. And the guise of the recovery of the amount under the surface proceeding, instead of putting the property belonging to the second respondent to the auction, the first respondent has in fact encroached the property belonged to the petitioner. What did they do?
They have shown their property where my property is situated. They have shown 57/2 and 3 survey number in the place of 57/1. That is the only issue.
Instead of the property belonging to the borrower, the respondent bank has put the property belonging to the petitioner to auction, considering the submission that he is unconnected with the proceedings. Why you cannot approach the DRT?
Listen, since, my lord, section 17 is, my lord, I am not claiming either any right over the security.
Not necessary.
Please,
You are
please.
aggrieved by an action of the bank.
Definitely.
Any of the steps that are taken under section 17.
Definitely, my lord, but definitely I will not get any relief from DRT since, my lord, I am a completely third party. I am nowhere concerned
No,
with this.
no, anybody.
Please,
Why
my
will
lord.
you not get the relief?
That's with
You
respect-
don't have to assume that.
I agree, my lords. With respect to the section 17 is concerned, my lords, when the respondents, my lords, without disclosing these irregularities to the action purchase, and my lords, they have continued with the sale.
No,
Please.
that's what it will decide. The DRT will decide what are all the steps that are taken with the bank or not, are correct or
when-
not. It could,
May I submit minutes? When irregularities.
because it is 23rd, you will come to High Court.
Please, minutes. When irregularities are found, apparently found on the face of the record, my lord, this
First of
court may
all, cooperate this, under the surface of proceeding, this Kodagu District Cooperative Central Bank. The writ petition will not lie to this court. I'll give you the liberty, the petitioner has an effective alternative remedy. Before the writ petition is filed, seeking the following prayer.
With respect to
Petitioner
alternative
has an
remedies concerned,
effective
my lord.
alternative remedy against the remedy before the DRT. It is a submission of the counsel that he is a third party. Even as per section 17, even a third party, any person can approach the DRT against the steps taken by the bank. Considering the urgency, as stated that the auction is going to be conducted on
23/4. 23/4.
26/4/2026. The writ petition is disposed of, giving liberty to the, no, instead of the bank, the petitioner has to avail the appropriate remedy before the DRT. However, considering the auction to be so and so, the respondent shall not proceed with the auction. List this matter on 28th of April. By the time the petitioner shall serve the notices, hand summons on both the respondent 1 and 2. And on that day, in the presence of both 1 and 2, the matter will be disposed of, giving liberty to the petitioner to avail the remedy before the DRT.
Bill number 33.
Deeply obliged.
33, Vinay Kirtiyam.
Appear for the petition. Your Lordship, the second respondent and third respondent created the documents and availed the loan, created the GPA of
To a
the
writ of
petition.
certiorari containing the impugned auction dated, published in the, you are questioning the sale notice.
Yes.
Then to settle the outstanding amount and a one-time settlement.
We are become a third party. Neither I am the borrower nor that. The second and third.
Why will you pay the one-time settlement?
No, Your Lordship, second respondent created the GPA. On the basis of the GPA, he sold the property to the third respondent. Now both are absconded. We are trying to that. For that reason.
For Bank of Maharashtra, who appears?
Bank of Maharashtra.
Any counsel, panel counsel? You appear? The so-and-so is directed to take notice on behalf of the respondent.
Ravishankar.
Land counsel for the petitioner shall serve the copy of the writ petition on the counsel. Tomorrow get instructions.
Tomorrow, Monday. Tuesday, your lords.
When is the auction?
Tomorrow is the action.
Get instructions tomorrow. Or else we have to stay the auction.
Yeah,
Tomorrow.
please, your lords, tomorrow.
Tomorrow. In the
Let
name
them
of
give the
so-and-so.
copies of the same, your lords.
Now itself.
And you serve the papers right now.
Yeah. Now
Yes, next.
34,
You take that.
Please, please.
Yes.
34,
My lord,
Balraj AC.
I appear for the petitioner, my lord. My lord, petition is a borrower, my lord.
Hmm.
My lord, he has raised a loan, my lord, to the tune of 17 lakhs, my lord, to purchase the house property, my lord. And because of loss of business, my lord, he could not repay the amount. And my lord, earlier, my lord, this.
You are a borrower.
Yes, my lord.
Why should we quash the vacate
My lord,
notice?
possession notice, one month submission, my lord. Earlier, my lord, as per Annex B, possession notice was issued. I approached this honorable court. This honorable court has granted an interim order subject to deposit of 30%, my lord. I have deposited the 30% and that still, that petition is still pending with the court. Now, my lord, once again.
What is
similar-
that writ petition?
My lord, WP number
List along with that tomorrow.
3964 of,
Write on a paper and give.
please.
List it along with that tomorrow.
Bill number 35. Yes, Prasanna Kumar.
I'm challenging the auction notice, annexure A, my lord, at page 18.
We can't file a writ petition against this before this court.
My lord, this is not just a regular, any auction and the bank issue. This bank is pertains to Shri Guru Raghavendra Bank, my lord. Since 2020, I have been approaching the bank for seeking for the statement of account. There has been irregularity and misappropriation funds in the bank. RBI has appointed an administrator in this bank, and the administrator refused to give me the statement of account. I approached this honorable court in 2020. this honorable court by order Annexure C directs them to provide me the statement of account, and I'm the secondary borrower. The primary borrower, my husband, has died in 2024. Even after the court order, they refused to give me the statement of account, and the delay for 4 years of not providing the statement of account, the reasons are well known to the administrator. After that, we have been regularly approaching them for an OTS with the amount, and I have taken only 1 crore 20 lakhs, Milord, and I have been ready to pay the amount with nominal interest rate, but they have been refusing my request. I have produced all the annexures with regard to my OTS
Content
request,
please
Milord.
come. The present writ petition is filed. Seeking the following prayer. The respondent is the administrator Sri Guru Raghavendra Sakara Bank Niyamita in another, in the light of the law laid down and so and so, the writ petition is not maintainable. Accordingly, the writ petition is the same section 14. Yes. Next.
Milord, auction was scheduled for today, Milord.
For admission matter, cell number 36, G. Lakshmi Rao, MFA.
Yes, admit force for final hearing.
Cell number 37,
This also admit.
cell number 38,
No, in 37.1,
furnishing of place.
this 37 don't admit, that is, in 37.1, the needful shall be done within a week, or else the writ petition against star 4 shall stand, the appeal against star 4 shall stand dismissed without further reference. 38,
38,
yes, this also admit, final hearing TCR. TCR is there, final hearing, yes.
Tribunal hearing P group, cell number 39.
Here for the petitioner. Your Worship, I seek for a short date. Any date next week is also.
What is
acceptable
urgency, why the
subject.
memo is moved?
My lord, for disposal of the case, I have filed the memo, my lord. The reason is the respondents are all purchasers of apartments in an apartment complex constructed by the petitioners, my lord. Now, instead of issuing sale deeds, they have issued share certificates, which is not recognized in the state of Karnataka.
What is a sale deed? For a property, there has to be a sale deed. What is the share certificate?
That is the main question, my lord. What has happened in the earlier writ petition, this honorable court had directed the registrar of cooperative society.
There is an interim order in this.
Earlier order is there, my lord. Your lordship turns to page 169, annexure L. There is an order passed by this honorable court.
Let's see the prayer. Where is the prayer?
Petitioner's prayer, my lord, is
Page 19, you know.
Passing the order dated 12/3/2015, passed by the Deputy Registrar of Cooperative Societies. Let us see the order.
your lordship sees the order. Relevant portion is at page 38. Conclusion. And before that, my
Page
lord,
number?
page number 39 is the order. Five. Page 39, in page 39, your lordship gets it, my lord.
The respondents are hereby directed to produce statement of
Statement of
accounts for
account.
having taken all sums of money from the persons who have taken flats in the Diamond District Apartment. Make full and true disclosure. This is the order.
That's all, my lord.
That is questioned here.
That is question, man. That
There is
order,
a stay from
that order has been, my lord, that's,
2015.
this order has been passed in pursuance of a direction issued by this honorable court. It's only in compliance of an order issued by this
When is
honorable.
this interim order passed?
Your
Let us
lordship
see.
sees page 169.
No, dated. When is the order?
This order is dated.
So I don't understand why the matter should be stayed and why, no, they have asked for the information. You provide the information.
March
Because I will just
2015,
make, I will just take this court through the brief facts which led to this order. The first submission made by the learned counsel for the respondent that the arrangement between the parties was that they were going to purchase apartments itself is not borne out by records. I am a company, I floated a scheme whereby I was developing a residential apartment complex. As per my scheme, which remains unchallenged by the respondents, your lordships, even till date, they are all subscribers to this scheme. As per the terms of the scheme, I said you can subscribe to my shares. Proportionate right to use and enjoy the immovable properties will then be given to them. They will even have the right to enjoy income from that properties, but the underlying land and the building will solely vest in my favor. In the right of ownership will not be transferred to them. This is a scheme.
Where is that agreement?
Annexure D, your lordship.
Page number?
Page 59.
Let's see.
I will just read out, Village. The property bearing survey numbers so and so, situated at Kodihalli Village, Bangalore, Airport Road, Varthur, Hubli, Bangalore, South Taluk, Bangalore.
4. Come to 4.
Please. Units will be provided to members of the company for their exclusive use and enjoyment on the following terms and conditions. Each shareholder has to obtain 2 equity shares of 10 rupees each of per square foot of super built up area of unit allotted, and 400 equity shares of rupees 10 each per unit of car parking. The aforesaid shares can be obtained either by allotment from the company or by way of transfer. The distinctive number of shares of the company are identified with each other and car parking unit in the manner set forth in the annexure. A person interested in acquiring the right of enjoyment of a unit will have to acquire the corresponding shares and pay therefore in the manner agreed to between him and the company. Your lordships may kindly see clause 6. I will read it out. By virtue of shareholder acquiring requisite number of shares and the deposit, shareholder will be given a specific unit with or without car parking.
You will collect the money for construction of the building. You will construct the building, and you're the owner of the property. He will only enjoy the property.
He will enjoy the property and he has shares of my company. I have also in this scheme, your lordships may kindly see the next page, page 62, undertaken that while the company will be the absolute owner, clause 7, will be the absolute owner of the land as well as the entire superstructure. However, the company agrees not to encumber the property after completion of the structure and delivery of possession to shareholders, not to carry on any activity other than maintaining the superstructure constructed by the company. By this, what I mean to say is they are not stuck here. We have not left them in a limbo. They hold shares of my company. The shares are even transferable and inheritable. Those are the rights that we have given them. After subscribing to this scheme.
No, for example, he spends, you collect from, for construction of 1 unit, you collect 10 lakhs from him. Please. So you will give him 10 lakh shares.
Please, Manoj, not each share will be valued at 10 rupees each. So we will give them the proportionate number of shares. And
that's what I'm saying. You collect 10 lakhs for construction. Please. And you give him 10 lakhs of shares. Whatever it is, 10 lakh what shares?
1 lakh of shares.
Huh?
1 lakh of shares, because each share is valued at 10 rupees.
No, I'm saying you have collected 10 lakhs.
Yes.
That means whatever worth 10 lakhs shares you will give.
Please. And they will have the right to enjoy and use the residential unit.
That means they can stay forever.
Please, Malaz, until they transfer the shareholding, as long as they are shareholders of our company, they continue to use that. They are now coming before courts and saying they now want complete ownership and they want sale deeds to be executed. However, they have also asserted their own rights as shareholders by filing a winding up petition against me before this honorable court. That winding up petition, ultimately advertisement was issued. We challenged it in before the division bench. The division bench allowed our appeal and matter is now pending before the Honorable Supreme Court. When they have already asserted their rights as shareholders, they can't now, your ladyship, come before this court and assert rights.
No, why did they go before the Register of Cooperative Societies?
Your lordship may kindly see the order at Annexure L. Page 169.
Where is this individual agreement between who are the petitioners?
Because we produced illustrative agreements since the petitioners are several in, so the respondents are several in number. Annexure E,
Let's see one agreement.
please, page 63.
Page?
Page 63. Lordships may kindly see the recitals at page 65.
Page?
65.
Just, thank you, sir.
The second unnumbered recital starts with whereas under the scheme.
Whereas?
Under the scheme,
65,
please.
under the scheme.
Whereas under the said scheme, a person on becoming a member of the company and holding a specified number of shares and maintaining a specified amount as security deposit with the company will be allotted a specific commercial or residential unit with or without car parking unit and with or without exclusive right of use of terrace area, together with a perpetual, uninterrupted, absolute and exclusive right to use and enjoy such unit and the common areas and facilities, along with the right to exploit, let out or otherwise enjoy the same and appropriate the income, usufruct and other benefits therefrom, with such member also having the right to dispose of such share, deposit and right of enjoyment of the unit allotted by a document, inter vivos or otherwise. Whereas the member is a shareholder of the company and as such is entitled to be allotted a unit pursuant to the aforesaid scheme, subject to the member paying deposit to the company in the manner hereinafter set out. Your Lordships may see.
Then what is the dispute raised before the registrar?
The dispute raised before the registrar.
Page number.
The impugned order itself, I will take your ladyship through. Annexure A, your ladyship, starts at page 22.
22. Yes.
The operative portion.
What is the case?
The sum and substance is recorded by the impugned order itself at page 28, para 1, sorry, the preamble. It says dispute in this case pertains to the applicability.
No, first of all, this case of applicants, the case of the applicants is that they are all residents and owners in possession of the residential units. How can you term yourself as an owner when there is no, when the ownership is not passed on to you?
My Lord, for that, my lord, I want to draw your lordship's kind attention. There is only one act which regulates the apartments in the state of Karnataka, my lord. That is the Karnataka Apartment Ownership Act. And there is one more act called the Karnataka.
No, that's a whole difficulty. You are not the owner of an apartment.
My lord, that is the dispute that they are.
No dispute. No, the genesis of this and the source of your right or authority is a particular agreement entered between you and the company. As per the agreement, it never says that you are the owner of the property. At best, you are the owner of the shares.
Lord, I request your lordship to take the Karnataka ownership flats regulation of the promotion of construction, sale, management and transfer Act 1972. This is the act, my lord, which governs the construction of apartment and sale of apartments in the state of Karnataka. The method is that once the apartments are constructed, they have to enter into registered agreements for sale of the property in favor
No,
of.
that is the whole dispute. Where is the
act says.
Both of you are two contracting parties. You have entered into an agreement, conscious of the fact, what are the rights that are flowing from such agreement? That agreement is very clear. As per that, you will be given the shares, and no, there are these kind of, what they do, they will construct some kind of villas or some resort kind of places where you will not get the ownership of that particular thing, but you will get the right to enjoy it whenever you go there.
Lord, here it is not a resort. It is an apartment, my lord,
Show it one document that is there between you and the builder,
I will
where
point
the
out.
ownership rights are given to you.
True, man. I'll point out from the act, section
Not
17.
the act.
No, what the
First
section?
of all, we have to look at the agreement.
Correct. I'll just come to that also, my lord. Section 17 says that the parties cannot enter into any such agreement at all. The agreement itself is void. What is recognized under the act is the agreement for sale and the sale deed, and the transfer has to take place under the Transfer of Property Act, my
There
lord.
is no agreement of sale, that's what it is.
That is the illegality. That is why this honorable court had earlier directed an inquiry to be held into whether sale transaction had taken place, whether they have collected the full sale consideration, and instead of executing a sale deed, they have just issued
Where
a
is,
sale.
how this cooperative society registrar is getting the jurisdiction?
Yes, that is under the act, my lord. That is, your lordship may kindly turn to the earlier order of this honorable court, page annexure L for a minute.
No, there are two aspects. What they have done is right or wrong is altogether different aspect. Now, you have an agreement of sale, whatever it is, parties are governed by the terms and conditions of the sale. Nowhere, neither they have promised you that they will give you a apartment, they will sell the apartment. They made it very clear that you will not get any ownership rights. Ownership vests with the company. You will have for the money you pay, you will get the shares. You sell those shares. Those shares are alienable, heritable.
That is not recognized in the state of Karnataka. That is the method of.
Entering into this kind of agreement is recognized in the state of Karnataka.
Even that is illegal, not recognized in Karnataka, is my humble submission. That is because statutorily it is barred. Your lordship take section 17 of the Karnataka Ownership Flats Act. I'll just read that one portion, Your Honor. My lord, section 17, act to be in addition to Transfer of Property Act and to override contract to the contrary. The provisions of this act, except where otherwise provided, shall be in addition to the provisions of the Transfer of Property Act 1882 and shall take effect notwithstanding anything to the contrary contained in any contract. My lord, the object of this act is to ensure sale deeds are registered, stamp duty is paid, and the transfer takes place according to the Transfer of Property Act. They cannot create.
Why did you agree?
Please, my lord.
Why did you agree? Why did you enter into an agreement of that nature?
My lord, they issued the certificate. There was no question of agreement. Instead of executing a sale deed, they have issued a share certificate.
When was this? You are a signatory to that.
Even if I am a signatory, what section 17 says that notwithstanding anything contrary contained in the contract, this is not applicable. Contract is.
The interim order earlier granted is extended. Is this matter after vacation?
Your Ladyship, the interim order has been extended till further orders on the last date.
Yes, after vacation.
Item number 40.
For the petitioner, my lords.
Please go.
Number 2, present in person, my lord, and file a memo along with the related case laws, my lord.
My lords, the present position of law is, I'll just complete, please. My petition.
Let me complete.
This is my petition. Let me complete. My lords, page number 87 of my writ petition.
First of all, what is the prayer you are
Please, that is the reason. 87. This is a complaint filed by the father as against his son. My lords, in respect of a gift deed that was executed out of love and affection. Now, this complaint was filed by the father in the year 2017, my lords. 16 months. 18, my lords, pardon me. The prayer in his complaint, my lords, may be perused. Page number 86.
Yes.
The first prayer being seeking the tribunal to set aside the gift deed as null. Set aside the gift deed as null and void as provided under section 23 of the Act, my lords.
This application is filed in the year 2018.
18,
When
please,
was
my
the
lords.
document executed?
My lords?
When was the document executed?
2012, my lords. I shall take my lords to the gift deed.
What are the reasons stated that?
Only out of love and affection. There were no conditions prevailing in the gift deed.
No, what is the reason what he says?
What he says is, in his complaint, there are no pleadings which state that the son was required to take care of the father. Even in fact,
my lords may also go through section 4 and 5 of the Act. Gift deed starts from page number 49, my lords.
What is the order of the authority?
Order is at page number 136, my lords, if I could take my lords to page number 136. And the operative portion, my lords, is at page number 144.
So the gift deed executed in respect of a property where now you are staying and he is
No,
thrown
no,
out
no,
of
it's
the
a vacant land. It's a vacant site.
vacant land.
Please, please, the vacant site. Even to this date is vacant, my lords.
Yes. What do you say, Mr. AGA?
My lord.
It cannot be. Cannot be done.
23, 23, no question of 23. That's wherever there is.
Can't be done.
There are this way judgment
Past
and
is, my lords.
Yes,
there
Position
are
of
two
law.
country judgments.
yes. What do you say?
My lord, I am filing a memo along with the related case laws.
There are case laws are against you.
My lord, that recent case that is passed in the case of that Urmila Dixit versus Sunil Sharma
Please
Dixit.
pass on, let me see.
Urmila is
I
in
have
his favor.
annexed that case law as well, my lord. I shall pass it up first to your lordships. So your lordships may
So
go to.
judgments are.
Yes.
That is,
In
Urmila
Urmila Dixit,
Dikshit.
in that case, my lord, what the Honorable Supreme Court says, what they've held is, when there is a condition that you will have to take care of the parents, in that case, yes, it has to be set aside. But my lord, Sudesh Chikara's case is very clear that there has to be a condition specific in the
no,
gift deed,
No,
which is
I
not
beg to
there.
differ to that principles of legal. That since Sunil Sharma Dikshit, even when there is no condition also, because the object of the enactment is to provide the necessity to senior citizens, the holds and distinguish the judgment of Chikara, where there was a reference in respect of Chikara judgment, but holds in favor of the senior citizen.
Well, that
The
is,
Chikara judgment holds in favor of the petitioners, but there is one more judgment of the division bench of Honorable this court, the Anjappa case, where they have followed the Chikara judgment. And there is one more judgment of this Honorable Court in a single bench, where they say that no, even in there is no condition under the gift deed, section 23 is applicable. That is Honorable Justice Suraj Govindraj. That all judgments that I have placed your lordships. And lordship has to take a view, either to follow the Supreme Court judgment of Chikara or
the present law
There
prevails.
is no choice either to follow or not to follow.
no.
There is a Supreme Court
Because
judgment. we
two
have to
judgments, my
follow.
lord. The Sunil Sharma Dikshit is in favor of the senior citizen.
Let us read this.
My lord,
Urmila Dikshit, what is the
my lord,
very
page number 33 first, my lords, of my compilation. Page number 33, what I have produced before your lordships. Page number 33, my lords, it talks about the submissions made and what the Honorable Supreme Court has held. My lords may come to page number 34. Para number 12. Subsection 1 of section 23 covers all kinds of transfers as is clear from the use of expression by way of gift or otherwise. For attracting subsection 1 of section 23, the following two conditions must be fulfilled. My lords, this is very important, my lords. Condition number A. The transfer must have been made subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor. Condition B. The transferee refuses or fails to provide such amenities and physical needs to the transferor. If both the conditions are satisfied by a legal fiction, the transfer shall be deemed to have been made by fraud or coercion or undue influence. But in the present case, the respondent is a practicing advocate. Please. My lords, may read further, please.
This is, and what is the other case?
Urmila Dixit, wherein the Urmila Dixit's judgment, it talks about the
No,
fact.
you are saying about the another Supreme Court judgment.
Chikara. Sudesh Chikara versus.
Which I've just now read out, my lords.
2024.
This is what I've read out, my lords, just.
No, this is Urmila Dixit. That's
Urmila
not
Dixit
what we
subsequent judgment of 2025.
Urmila Dixit talks about the fact that since.
have. We will see 27.
Sudesh Chikara's case, my lords, in my compilation starts at page number 27, which I read out, those relevant paragraphs.
Oh, this is Chikara's case.
Please.
Then what about this Urmila Dixit's?
Urmila Dixit, my lords, in that case, what happens
See
is,
that. Let us
please,
see the
page
judgment,
number
then you can
38, my lords.
submission.
Starts from page number 38.
Kindly see para 20 onwards where the Sudesh Chikara was made a reference to that. Para 20 of the judgment.
Page number 47, my lords, para 20.
Yes. It is the facts, the position, what is laid in Shikara's case was not interfered in this Urmila Dixit's case.
Yes.
Kindly
The
see.
facts and circumstances of the case, they felt that the particular complaints of section 23 or the two conditions are present in that and now allowed. So there is no contra-view in Urmila Dixit and the Shikari's case.
Kindly
What
see.
about the division bench's judgment? Where is it?
That is Nanjap versus State of Karnataka. That is
That
in
is
favor of the petitioner.
Nanjappa?
Nanjap versus State of Karnataka. Writ appeal
Based
number.
on those judgments.
Yes.
rather than-
That is
Let's see
in
this.
favor of the petitioner, where they have followed the Chikara judgment.
No, that's the law. That's the law.
Even then, my lord, kindly see para 21 of the Sudesh Chikara, the Urmila Dixit judgment. May I read, my lord?
Yes.
Further in Sudesh, so and so for attracting the application of section 23, the following essential were expounded. The transfer must have been made subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor. The transferee refuses or fails to provide such amenities and physical needs to the transferor. Adverting to the facts at hand, we find that there are two documents record. One, a promissory note dated so and so, which records that the promisor shall serve the appellant and her husband till the end of their life, and in the absence of him fulfilling such obligation, the subsequent deed can be taken back by the appellant. Second,
What on
the-
factual aspect?
Yes.
I've seen that.
no, there it is thereafter, my lord. The second, the appellant has submitted to us that such an undertaking stand grossly unfulfilled, and in her petition under section 23, it has been aware that there is a breakdown of peaceful relations inter se in the parties. In such a situation, the two conditions mentioned in Sudesha must be appropriately interpreted to further the beneficial nature of the legislation and not too strictly, which would render attest the intent of the legislature. Therefore,
Oh,
the
for
single.
example, in this case, a gift deed is executed in respect of a residential house where he is staying. Now, after getting the gift deed executed in favor of the son throws the father out of the house. And in that situation, he goes before the authority. Then it is altogether a different scenario.
No,
No, it isn't. That's why he says it's an open vacant land.
my submission is that now there is a divergent views.
There is no divergence, that's what I'm saying. But then the facts and circumstances of that case, in the case that, what is that, Urmila Dixit's case, Initially, there was a promissory note that also talks about it. Then there was a gift deed. In the gift deed also, there was an averment that they should be the senior, that whoever the father or the mother have to be taken care of.
Even then also the Supreme Court says that even if in absence of that also, since it's a benefit legislation, the
No,
benefit was
that is-
passed on
that
to
there is
them.
no
Not
such
rightly
a-
interpreted.
Come, please come, you read it again.
Please.
That's not what the Supreme Court said.
Page 47,
Number
para
in your,
20.
40?
Page 47, para 20.
Uh,
What my learned friend is
Different
referring to.
contentions of, different observations of the High Court are dealt with. But ultimately, the view taken in Shikara's case is affirmed.
Please. My lords, in Urmila Dikshit's case, the reason why it was allowed was because there was a condition prevalent in the prevailing. in
That's
the-
what
Please, my-
I've seen.
Please, my lords.
You're reading paragraph?
Page 47, para 20.
No, in 20, they have extracted that Shikara's case.
Tikara, yes, 21,
Then 21.
22.
Then that is,
Yes.
then 22. Then
22
it
may
has
not help.
discussed
madam.
about the facts specific to
Yes,
that case.
yes, 24 may help.
Uh,
Before parting with the case and we must clarify the observation made while impugned order for the competency of the tribunal to hand over possession of the property. In Vanita, this court observed that tribunals under the act may order, Vanita.
The AGA, this is entirely different. There is no observation with regard to section 23. It is only with whether the courts have the powers to give possession of the property. On that aspect, this Vanita's case, in that reference, this is the discussion.
Please.
This court observed that tribunals under the act may order eviction if it is necessary and expedient to ensure the protection of the senior citizens. Tribunal considering while exercising also cannot order possession to be transferred. That is the issue in under 24. Not about, this would defeat the purpose and object of the act. Speedy, simple, so and so. This is with regard to the eviction.
There also, in our considered view, the relief available to senior citizen under section 23 is intrinsically linked with the statement of objects and reasons for the act. That elderly citizens of our country, in some cases, are not being looked after. It is directly in furtherance of object of the act and empowers citizens to secure the rights promptly when they transfer property subject to the condition of being well-being.
Subject to the condition.
My lords, even in the case, my lords, even in the cases of
No,
eviction.
for
Please.
nothing, no other argument is required. Yes, Mr.
Please, my lords, please.
Yes.
My lord, I want to file a memo along with that case laws.
Yes, this is
Brilliant
Urmila
case law.
Dikshit's case.
Yes, my lord.
That I have seen.
However, that it is to be brought on record for
Yes,
submission.
please give it. Take that. Urmila Dikshit. And what is the other judgment? Sudesh Shikara. Yes. And the High Court orders. Let's see the High, what is this, 23 to 31? Delhi High Court. What did the Delhi High Court say? Paragraph number?
23. Page number 23. 23.
For what purpose you relying on this judgment? AR 2025 Delhi 153.
Even then, my lord, it's just now the full bench judgment of the Kerala High Court. That is also pending for before the Honorable Supreme Court in itself, where the full bench holds that there must be a condition precedent in the gift deed to apply section 23.
No, under Senior Citizens Act, if they want the other release with regard to the maintenance and all, that would be taken care of. Now, in this manner, something which is executed about 10 years back, under the guise of this act, if you start, interfering and setting aside that, then.
Your Lordship has already taken a view that 23 is not applicable.
This is 23 is very clear, my lord. That is.
No, you're relying on AR 2025 Delhi for what purpose?
The purpose that is condition need not be incorporated.
Where
in
is
the
it? Where did the Delhi High Court say that?
The page number 46, my lord.
No, the judgment that ends at 31.
Page number 46, para number 32. In other words, the act acknowledges that property transfer from senior citizen, especially to children or close relatives, are often motivated by love and affection. The senior citizen decision to.
Which judgment you are reading?
My lord,
Which judgment you are reading?
that is now they presented.
No, that's what, you just
The
page
page number
now.
46, serial number,
Madras-
serial number
Madras High Court,
46, para 32.
It's a judgment of High Court of Madras, my lord.
No, before that I've asked you, come to page 23 of your, 23.
23.
Yes. In this judgment, which paragraph you are relying on? Delhi High Court judgment.
Para 4. Page 4. Page 14.
My lord.
It is under maintenance, not unto 20.
The para 14, my lord, the aims and objects of the Maintenance and Welfare of Parents and Senior Citizen Act 2007 are very clear and provide a mechanism to secure maintenance and ensure welfare of senior citizens who may have been neglected or left without any support, both financial or otherwise. It is right that the Act is a piece of social welfare legislation which ought to be construed liberally and implemented to further the aims and object contained therein. We do not consider dilating further on this subject or examine the provision in as much as the learned single judge has examined the appropriate provision with excitable exitude. Further, para number 15, this court has perused the material on record, particularly the original complaint dated so-and-so filed before the district magistrate, the MLC dated so-and-so 30th September 17, the complaint dated 1/10/27 lodged with the SHO, PS Jaipur, and the orders passed by the lower authorities. No doubt that the procedure prescribed under the Act is summary in nature, yet the authorities like district magistrate at the first instance and the district divisional commissioner has the appellate authority or fact-finding authorities who need to appreciate the facts obtaining in a particular case.
Yes, I've seen that. Please come.
My lord, my only last submission. The mother is with the children, with the petitioner. The mother, in this case, his wife, he's deserted his wife. The petitioner in this case has been taking care of his mother. I wanted to place this on record, my lord.
Please come.
Please.
The present petition is filed. Seeking the following prayer. The petitioner before this court is the son. The second respondent is the father. Third respondent is a daughter.
Please.
Where
Yes.
you, who representing third respondent? Notice is served on her.
He stays with his daughter, my lord. He's staying with his daughter.
No, who represents her?
No, we are there.
Notice is served. Third respondent is the daughter. The father has filed where is the order?
Well, order is at page number 136. The page number 136, annexure P. The operative portion is at
The
page number.
father has
144.
approached the Assistant Commissioner under the provisions of the welfare of parents, maintenance and welfare of parents and senior citizens Act. He has filed an application under section 23 of the Act. That is Maintenance and Welfare of Parents and Senior Citizens Act 2007, hereinafter referred to as Act. Seeking cancellation of the gift deed dated 23/11/2012, which is recognized, registered on 12/7/2013, pertaining to the scheduled property in favor of the son, that is the petitioner herein, and further sought the direction to quit and deliver the vacant portion of the property to the father. The parties are referred to as father and son for the sake of convenience. The It is a case of the father that is the absolute owner of the property. And out of love and affection towards his son, he has executed a gift deed in the year 2012, which is registered in the year 2013, on to 23/11/2013. It is the case of the father that after obtaining the gift deed, the respondent became very greedy and violent against the petitioner and started harassment and assault very frequently, due to which the relationship between the petitioner and the respondent, between the father and the son, became stale and reached to a worse situation. Even the the father has filed a police complaint with the jurisdictional police. The father is mercilessly thrown out of the house on 7/1/2007, keeping all belongings, and presently he is staying with his daughter. Hence, he has come before the tribunal and with the reliefs as discussed above. It is a case of the son that the father has voluntarily left the house, even though he is providing all basic necessities to the father. It is a case of the son that during the year 2015-16, without no reason, the father started behaving detrimental to the interests of the family members by listening to the third persons who are unconnected with the family. He has started listening to the daughter and the son-in-law, and they polluted the mind of the father. And ultimately, the father started to communicate with the children by writing notices to all his children. Further, the wife and the son were isolated. Then the father, when nothing has rectified, the father has left the family. It is a case of the son that the mother is staying along with him and father has left the company. And according to the son, the father, such a relief cannot be granted by the assistant commissioner. The assistant commissioner, by order impugned, had, by exercising the powers conferred under the Act, has cancelled the gift deed dated 12/7/2013 and declared it as null and void, and directed the jurisdictional sub-registrar to comply with the order. While passing the order, the assistant commissioner has discussed the purport of the Act and section 23 of the Act. It is observed that the reasons behind approaching the tribunal by the senior citizens for the reasons that they have been neglected by the children and for other reasons. The Act is a special beneficial act for the welfare of the senior citizen. It is quite apparent from the records that that the son may have been harassing the father, due to which the father approached the police station several times. If at all the son is taking care of the father with love and affection, as previously taken care, he wouldn't have approached the police station several times and the tribunal seeking justice against the son. And hence, the court, the petition is very much maintainable and accordingly passed the order. Agreed thereby, the son is before this court. When counsel appearing for the son submits that under section 23 of the Act, the assistant commissioner has no such jurisdiction to set aside the gift deed in the facts and circumstances of the case where the gift deed, there is no condition in the gift deed that the son has to take care of the father. In those circumstances, where a gift deed that's executed in the year 2013 cannot be cancelled in the year 2018. He had relied on the judgment of the apex court in case of Sudesh Chikara versus Srimati Ramti Devi and Nanda, arising out of civil appeal number 174 of 2021 dated 6/12/2022. He has relied on paragraph number
12, my lords.
He relied on paragraph number 12, 13, 14, 14. He also relied on the judgment of the apex court in Urmila Dikshit versus Sunil Sharan Dikshit and others, arising out of civil appeal number 10927 of 2024, dated 2/1/2025. That is which paragraph?
That again quotes the same para number 20, my lords, page number 47, which refers to the apex court's judgment.
He relied on,
20, 21, 22, 23, 24.
he relied on 20, 21 and
24, my lords.
22 and 24.
24.
Further, he has relied on another judgment of the apex court arising in civil appeal from civil appeal number 1, sir. What is that, the other one? Bombay High Court.
No, that's,
I've relied only
I-
on two, my lords. I've relied only on two judgments of the Honorable Apex Court.
Karnataka High Court, what is this writ appeal?
This again refers to the Apex Court's judgment, confirming
He also
the
relied
position
on the
of
judgment of
Lease.
the division bench of this court in writ appeal number 11154 of 2022 dated 19/8/2024.
Please,
in
the very
case of
first paragraph.
P. Anjappa versus Srimati V. A. Lakshmi and others, which has followed the judgment of the apex court in the Sudesh Shikara's case. Relying on these judgments, submits that unless and until section 23 is complied with, so the gift deed attracts the conditions under section 23. The assistant commissioner has no power to declare the sale deed null and gift deed null and void. The party in person, the father who has appeared as party in person, has relied on the judgment of the apex court in Urmila Dikshit's case, as well Sudesh Shikara. Further, he has also relied on the order, the division bench of the Madras High Court in writ appeal number 3582 of 2024, in case of Srimati S. Mala versus the district arbitrator and district collector, Nagapatnam district. He relied on paragraph
Fourteen and 14 and what? 14.
not 14.
14. 13, 14.
Condition need not be ordinary.
Section, paragraph number 24, and para 23, 24, 25, 29. Thirty-three also. But basing on this judgment,
There is one more judgment.
huh?
One more judgment. Venkataya versus State of Karnataka.
Which one?
Venkataya versus State of Karnataka. That is in my,
No, here, where is that?
that already placed that bunch,
No.
which is given by. No, the series of judgment which was given to,
Just
given by
Suraj
me.
Govindra's
Suraj
judgment.
Govindraj.
Which is that? What is the?
Venkataya
party-
versus-
Venkataya, He has relied on the judgment of a learned single judge of this court, a coordinate bench of this court in Venkataya versus State of Karnataka, reported in 2020 26 SEC online Karnataka 489.
Page 18,
number?
para 18. 18.
1 minute.
There they have distinguished the Sudesh Chekara judgment.
Paragraph number
18, 18 up to 18.14.
Till 18 to 18.14.
0.14.
Oh. Where it is observed that an express recital in the gift deed obligating the donee to maintain the senior citizen is not mandatory for invoking section 23(1) of the Act, and such obligation can be inferred from the surrounding circumstances and conduct of the parties. Relying on this judgment, it is submitted that the order passed by the Assistant Commissioner is legal and valid and in consonance with the provisions of the Act. Next one, Leonard HEA submits that considering the fact that the father is thrown out of the house and has not been taken care of, and considering the conduct of the parties and the plight of the senior citizen, then order has been passed by the Assistant Commissioner by cancelling the gift deed that is executed in favor of the son. It is submitted that the order that is passed by the Assistant Commissioner is in consonance with the provisions of the Senior Citizen Act, and there no interference is called for. Next one, having heard so and so, the undisputed facts in this case are: a gift deed of the year 2012 was executed in the year 2013, that is dated, earlier it is there, you write it, that is dated so and so. The present application is filed before the Assistant Commissioner in the year 2018. While passing with the order impugned, what has been observed by the Assistant Commissioner is that the father has given the complaint, he has discussed about the object of the Act, and further, father has given complaint to the police on several occasions. Had the son is taking care of the father, and had he been good with the father, he wouldn't have filed a complaint. And as it is, and the Assistant Commissioner has felt that in these circumstances, it has to be inferred that the son is not taking care of the father. As such, the gift deed has to be set aside, and accordingly has set aside and held that is void ab initio. The Honorable Apex Court in Urmila Dikshit case and even in Sudesh Shikara's case referred supra has discussed the scope of section 23 of the Act. At this juncture, it is appropriate to extract section 23 of the Act. Please extract the Act. The Apex Court in the said judgment, considering the respective contentions of the parties, has specifically dealt with the scope of section 23 of the Act, and also has observed that to satisfy section 23 subsection 1 of the Act, the party shall fulfill that the transfer must have been made subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor, and the transferee refuses or fails to provide such amenities and physical need to the transferors. If the conditions or not satisfied, if the conditions are satisfied by legal fiction, the transfer shall be deemed to have been made by fraud or coercion or undue influence, and it becomes voidable. And the court and the apex court has observed that whenever an application is filed under section 23 of the act, that such conditions must be established and established in the said deed. The petition has relied on the father has relied on the judgment of the Madras High Court and also a judgment of the a coordinate bench of this court. When Venkatappa's case, in Venkataya's case, in those cases, the interpretation that is given to section 23 is contrary to the judgment of the apex court in Sudesh Shikara's case. When the particular provision is interpreted by the Honorable Apex Court in a particular manner, when the law laid down by the Honorable Apex Court is the law of the land, it is imperative that the courts are bound to follow the same. In those circumstances, this court cannot look at the judgment of the coordinate, cannot follow the judgment of the coordinate bench of this court or the division bench of the Madras High Court judgment, and no other interpretation is possible in these circumstances in the light of the law laid down by the Honorable Apex Court in Sudesh Shikara's case referred supra. The gift deed that is executed in the year 2013 does not there is no condition in the said gift deed, and once there is no, and it cannot fall, it fails to satisfy the conditions laid down under section 23 of the act, and accordingly the order passed by the assistant commissioner is set aside and the writ petition is allowed. It is left open to the father to avail the appropriate remedies, if any, in accordance with law.
My lords, gift deed 2012, my lords. My lords, that record.
No, but it's registered in 2013.
Obliged. Grateful.
Sir, number 41, Ravi Kumar MC.
In this matter, Lordship directed to seek instructions.
Yes.
Yes, my lord, in this matter, we have challenged, my lord, the arbitration proceedings, my lord, on want of jurisdiction. My lord, my instructions are that now, my lord, orders are, my lord, award has already been passed. This renders infectious, my lord, may kindly have it on Tuesday. I'll verify, my lord, if it, my lord, orders are passed, then this will not survive for consideration.
No, you yourself are saying that award is passed. What instruction?
What, my lord, is instructed by the.
That I will record. If it is something contrary, you can come up with a petition. Why should we unnecessarily adjourn it? Please come. The present writ petition is filed seeking the following prayer. It is a case of the petitioner that the arbitrator has no jurisdiction to pass and to entertain the proceedings. Then counsel for the petitioner submits that already the award is passed. In that case, this petition has become infructuous, and the petitioner can avail can assail the award that is already passed by the arbitrator. In that view of the matter, the petition is disposed of, giving liberty to the petitioner to assign the award that is passed by the arbitrator. Yes, next.
Next. Number 42 adjourned, 43.
Not 43, my lord, yesterday, your lordship, my lord, waited for the other side to come. I knew another private respondent. In this case, my lord, in 20514 of 2021, Lord, the assistant commissioner, my lord, nullifies
Senior citizen.
gift deed which gets executed in the year 2014, my lord.
Oh. Yesterday's case.
Yesterday's.
Yeah.
But in the year 2014, Lord, the,
So it's a big checkered.
please.
Please come to the cost title again to refresh my memory.
Page number 3, my lord.
So, according to you, what I remember yesterday, the originally gift deed is executed in favor of the son.
My lord, in favor of the fourth respondent.
That is a daughter.
My lord, a younger daughter of second and third respondent.
And they have obtained the loan.
They obtained the loan. My lord,
After that, a gift deed is executed by the father-in-law in favor of your wife.
No. Now, my lord, the fourth respondent executes a gift deed in favor of my wife.
That is a sister.
And, my lord,
And you again obtain the loan and you give the loan to her.
Yes, that is the case, my lord. Now, after all this,
father-in-law will go to the
AC seeking, my lord, to
to
nullify
cancel the.
the gift deed, which, my lord, originally goes back to them. My lord, all this is to circumvent, my lord, the loan that they have to pay to the bank.
Ultimately, you have nothing to lose.
I have nothing to lose, my lord.
Then why have you come here?
And the only thing is, my lord, the order passed by the AC, my lord, is blatantly wrong. My lord, the gift deed, my lord, dates back to
Where is
2014.
the sister?
But they are before this court. Yesterday also, my lord, the lordship, my lord, directed and passed an order that if they don't appear today, lordship will be passing the order. They have been notified.
So, sister who has executed a gift deed in your favor has no problem. And she has also no problem with the gift deed that is cancelled.
Nothing, my lord. Now the father-in-law, my lord, comes up with this plea before the senior citizenship.
So now
court.
both the father-in-law and the sister-in-law are represented by one advocate.
One advocate, all of them. In the meanwhile, my lord, before they approach the assistant commissioner, my sister-in-law would file a suit which is pending adjudication, my lord, my lord, before the civil court. They don't get an
So
order.
how can one advocate represent the father-in-law and sister-in-law?
That is
They
what-
have the conflicting interests here.
Here, my lord, they don't have the conflicting interest,
Why
my lord,
not?
in another suit.
No.
Please.
No, by virtue of this order,
Please.
the gift deed that is executed in favor of your sister-in-law is cancelled.
Is cancelled, my lord, but she does not
And
prefer.
that is when that
They
is
are
a
all hand in
conflicting
glove, my lord.
interest.
They're
How
all
can one advocate appear?
They're all in hand in glove, my lord, to overcome, my lord, whatever they have to pay to the bank.
Then we'll dismiss, we'll allow it with costs to be paid by your father-in-law. Please come. The present writ petition is filed seeking the following prayer. The parties are, as per the cost title before this court, the petitioner is the son-in-law of the son-in-law of the third respondent.
Please, my lord, second and third respondent.
Son-in-law of second and third respondent. The father-in-law has executed a gift deed in favor of the,
My lord, the second, the third respondent has
the
executed-
mother-in-law has executed a gift deed in favor of the fourth respondent daughter. By gift deed dated
by gift deed dated, my lord. My lord, 23/6/2014.
2023/6/2014, they have mortgaged the property and obtained the loan. Thereafter, the fourth respondent has executed a gift deed in favor of the petitioner's wife, that is the fifth respondent,
On 27/8/2015.
on 27/8/2015.
Where second and third respondent.
Thereafter, the fifth respondent has executed a gift deed in favor of the petitioner on 30/11/2018. 18. And you have taken the loan?
Lord, I have taken the top-up loan, my lord, and
The
thereafter.
petitioner has taken the loan and he has given, according to him, he has whatever loan amount, loan he has taken from the bank, has given it to the fourth respondent.
Not fourth respondent, my lord. The second and third respondent.
To the second and third.
Including fourth respondent.
including fourth respondent. Now the third respondent has filed an application under section 23 before the Assistant Commissioner, that is MSC/CR/82 2018-19, to cancel the gift deed that is executed in favor of the fourth respondent.
Please.
Fourth respondent and subsequent sale gift deeds that are executed in favor of the petitioner and his wife. That came to be allowed by order dated 23rd July 2020. No, both the second and third respondents have filed an application under section 23 before the Assistant Commissioner. And by order dated 23rd July 2021, the Assistant Commissioner has passed an order cancelling the gift deeds dated 23/6/2014, 27/8/2014, 30/11/2018. The third respondent, who is the third respondent?
I am the third respondent before the
And the
AC.
petition is directed, oh, that is what? That is how you are
I
agreed.
am agreed.
The petition is directed to repay the loan available from the bank at his own cost and risk. What kind of orders are passed? While passing the order, the Assistant Commissioner has observed that has considered the submissions of the parties. It is submitted before the Assistant Commissioner that the three gift deeds of void have been issued as there is no intention to the senior citizens to permanently transfer the scheduled property in favor of the respondents. There is no intention to create right, title and possession in favor of any of the respondents in the property. And the gift deeds was standing in the name of the daughters or only the circumstantial one, and created the said two gifts on the assurance and promise, and they failed to keep the promise as well to maintain the senior citizens. The Assistant Commissioner gave a finding that the gift deeds are not for consideration and it is taken from the petitioner with a misrepresentation, undue influence and pressure. And all these transactions are unfair and invalid, and all the deeds are unsustainable under law. And the respondents have misused the property, and accordingly, no, it's not the one. These are all the contentions that was raised by the senior citizens. The court observed that it's an admitted fact that the Assistant Commissioner has observed that it's an admitted fact that the senior citizens have executed the registered gift deed in favor of the daughter for the purpose of raising loan from the bank for the benefit of the senior citizens as the father is a pensioner and the mother is housewife. And the daughter is an employed person and eligible to raise loans from banks or financial institutions. And they have only for the intention of raising the loan, they've issued the gift deed. Later, the daughters and the son-in-law have colluded and have again have induced the father and mother to lend their names to the gift deed executed by the daughter in favor of the other daughter, again some making from false promises and misrepresentations. Again, the daughter has transferred the property in favor of the son-in-law without their notice. Hence, the Assistant Commissioner has come to the conclusion that with a false promise, this gift deed has been obtained by the daughter. The notices are served on the respondents. For R2 to R5, that is to the daughter, to all the family members, that is to the father and mother, to both the daughters. One advocate is appearing. And after that, one advocate by name Vishnu Hegde on NOC filed wakalat for R2 and R3. The land counsel appearing for the petitioner submits that the gift deeds which are not accompanied by any recital with regard to the maintenance of the senior citizens, and the first gift deed which has been executed in the year 2014, in view of the differences between you and your wife, in view of the differences between the petitioner and the wife, they have come up with such an application. They've gone before the Assistant Commissioner under Section 23 of the Act. It is submitted that the Assistant Commissioner ought not to have entertained this application, which is filed beyond that is filed beyond the scope, which is beyond the scope of the Act, and court ought not to have cancelled the sale deeds. Though this matter has come up before this court, on all the occasions, there was a representation on behalf of respondent 2 to 5. Counsel for respondent number 6 is present. Land counsel appearing for the respondent number 6 submits that they have assigned this loan to the asset reconstruction company, and they have nothing to do with the said loan. Next part. Initially, the wakalat is filed on behalf of respondent R2 to R6 by one advocate. Thereafter, R2 to R5 by one advocate. Thereafter, for NOC is granted. NOC wakalat is filed on behalf of 4 and 5. None of the parties, though advocates have filed wakalat, they are not represented them before this court. And looking at the manner in which the transactions have taken place right from 2014 to 2018, and the gift deed, that is as per Section 23(1) of the Act, no recitals are found in the gift deed with regard to the maintenance of the senior citizens. It appears that with no of the disputes between the 5th respondent and the petitioner, who is none other than the daughter of the 2nd and 3rd respondents, the entire litigation has been initiated. When the when there is no recital as per section 23(1) and as per the judgment of the apex court in Shikari's case, in so and so in the earlier judgment you have taken, Shikari's case, the assistant commissioner has no jurisdiction to go into these aspects, in that view of the matter. The order passed by the, and on the face of it, there appears to be a collusion between the parties. It is nothing but a pure reviews of process of law. Accordingly, the order dated so and so passed with the assistant commissioner is set aside and the writ petition is allowed. Yes, next.
Bill number 44. Virendra Patil.
Yes.
But in this, for the
That's if I appear for respondent number 1 and 2.
Yes.
but the petition,
Yes.
the petitioner is a consortium of bank, but headed by the State Bank of India, they are the leading bank. But they filed recovery proceedings before the DRT against Kingfisher Airlines and UBHL and others. They are all the secured, they are the corporate guarantors against KAL and others they have filed. Then the DRT issued a recovery certificate for 6,203 crores and odd rupees with interest. Then there was some discrepancy was there, including the shares and other things. Where amendment certificate was also issued. Then the recovery officer initiated the recovery proceedings. What happened was he has opened the demat account in the third respondent security brokers, and
This is the Canara Bank. You are appearing. Yes. Yes.
the Canada Security, they may not be having any much objection in this. The recovery certificate, the recovery officer has appointed the third respondent as a broker because they are the share brokers and also they are holding the demat account. Then your last may kindly come to.
Is it that case with regard to that amount, who has to pay that?
Poundage.
Yes.
Poundage fees.
Poundage.
Poundage fees. This is the poundage fees. This last may kindly come to the annexure. E, the annexure A is the demand. Annexure E may kindly be seen. This is a proclamation of sale. So this is page 200. Annexure E, page 200. The proclamation of sale was issued for two proclamation of sale because two sets of shares were there. Totally 2 crore and odd shares were there. It was proclamation of sale was issued. Then they appointed
Yes.
page 200. The last but one paragraph.
I have seen this page number 17,
Page?
where the demand notice is issued to
Yes,
you
ma'am.
by the
That
recovery
is,
officer.
yes.
saying
That is
you have to
17,
pay
that is the
fund.
demand, that is the demand letter.
They do not know who is the purchaser.
Yes,
of the
ma'am.
share.
They say that they do not know who are the purchasers, therefore you pay the amount. They have issued a letter to a demand letter to the bank, consortium bank. Share has been sold.
Coming to how much amount?
This, it is about nearing about 80 lakhs.
80.
80.
80.
But the reason is, Ulashi may currently see the total shares, these about 2 crore and odd shares were there. But they having two different companies. That is Mangalore Finance, this Chemicals and Fertilizers Limited shares. Those shares are sold by the third respondent. But third respondent was appointed as a broker by the recovery officer.
Third respondent is a Canara Bank.
Canara Securities.
Securities.
Canara Bank Securities. That is the Canara Securities. The Canara Bank Securities Limited. They are also not in the security business. That is a subsidiary of the Canara Bank. Now, Ulashi may kindly see
They are the ones who sold.
They have sold it because the recovery officer, he himself cannot auction the shares.
Yes.
Because it has to be sold through the stock exchange. But the recovery officer has authorized the third respondent to sell these shares either through this Bombay Stock Exchange or National Stock Exchange. And appointment is very clear. Last may kindly come to the appointment of broker at page Annexure G, page 206.
Page 2?
206. Annexure G, Maran. They Last got it.
1 minute. 206.
Yes, but this, that the recovery officer is entitled to entrust this matter under Rule 46 of second schedule of the Income Tax Act. Not he is entitled to entrust this to the brokers
What
to
is
sell
that
the shares.
option under
Rule-
section?
Rule 46 of second schedule of the Income Tax Act. Lordship may kindly. Shall I read, madam? Only short.
Yes, yes, please read.
Notwithstanding anything contained in this schedule, where the property to be sold is a negotiable instrument or share in corporation, the tax recovery officer may, instead of directing the sale to be made by public auction, authorize the sale of such instrument or share through broker. Not a share necessarily has to be sold through the broker unless there are some persons and competition is there. That is a different aspect. Here, this property was sold through the broker. But this is a very important aspect. Then please come to Anashar G now.
No, you're reading something at 208.
Pardon, madam?
208 you were referring to.
206 may kindly. 206 and 8 both are one and the same. Are different shares. 206. This is the second para may kindly be. First para is only the total amount due 6,000 and odd crores.
Yes.
Then second para, the undersigned holds 23,300, 23 lakhs 13,788 shares belonging to Kingfisher's Finvest India Limited in measures Mangrove Chemicals and Fertilizers Limited, set forth in the schedule hereto with you, the depository participant in respect of the captioned department recovery certificate, and the undersigned intends to realize the said shares by sale, of which purpose you are hereby appointed as a security broker in terms of the provisions of section clause rule 46 clause 46 of the second schedule to the Income Tax Act to undertake the sale of the said shares in open market of the Bombay Stock Exchange or National Stock Exchange in the market, in the normal market segment through the retail sale or bulk sale at price of rupees 43 price range, because depending upon the market rate the share will be sold, and above per share 22.04 etc. onwards until further instructions. Then please come to next page.
The brokerage is fixed.
Yes, brokerage for the sale will be 0.04%. It is a fixed amount. This has been paid. No dispute in respect of this. Class 3 also, in class 3, GST and also paid.
No, brokerage will include all statutory costs.
Yes, all statutory costs, but everything has been paid. No, these are the two, the appointment letter to them. One is for 23 lakhs 13,000 shares. Another is for 1 crore 78 lakhs and 36,000 and odd shares. These shares have been sold. Brokerage.
The general in a given case, yes, whenever the broker is selling the shares,
yes,
in that case, who will pay the fees?
Brokerage charges, brokerage charges will be paid out of the amount sale proceeds. That has been paid.
Whatever this is called
poundage fees, poundage fees is a different concept. All this poundage fees is a totally different concept.
What is it? Poundage fees.
Poundage fees is not what it does. Poundage fees is not in existence in India actually. This is borrowed from England. In England, there was a bailiff, that is sheriff. Sheriff used to sell the properties, private properties, and their charges is called as poundage fees. That has been incorporated in Rule 57 of the Income Tax Certificate Proceedings rules. There is a provision that poundage fees, there is no definition as such, but we can understand from certain judgments that poundage fees is a amount payable to the person who's auctioned the properties, the private persons who auction the properties towards his commission and also for the expenses.
That is a brokerage.
That is the reason why once brokerage fees is paid, no question of paying poundage fees, because the person who is selling the property, or the person who is the authorized, is a public servant, is a recovery officer, is a government servant. He will be paid with the salaries and other things. Therefore, he cannot ask for any commission as such. Now the poundage fees is only as towards the commission and the expenses. Now here the brokerage charges has already been paid.
Second respondent is already getting that.
Yes, miss. They have
by
got
virtue of this document.
Yes, this document. The third respondent, they have filed a statement also. They said they have already received 3 lakhs and odd rupees. Brokerage charge.
Brokerage.
Brokerage and other tax and other things has been paid. by the recovery officer. That there is no.
But you are saying that that Poundage will come to 80 lakhs.
But that is now, the problem is now, last week only 2 crore and 1 lakh and odd shares. If it is sold it for 35 rupees, it comes to 70 crore rupees. 70 crore rupees, 1% is calculated, it comes to 7 lakhs and odd rupees.
7 lakhs.
Sorry, 70 lakhs, sir, not 7 lakhs, 70 lakhs. 70 lakhs.
Hmm.
It will be 70 lakhs. So that is not, they are not entitled, is my respectful submission. Reason is, but the recovery officer is.
So here it is like this.
Yes.
A person, you say,
Yes.
this Poundage fees is something
Yes.
which the person who has sold the shares
Yes.
is getting it, whatever the expenses he incurred
Yes,
or
sir.
for the
Everything
service,
is there,
for
sir.
the services he has done.
Yes.
So the brokerage of 8,000
Yes.
and this Poundage of 80 lakhs, 8 lakhs and 80 lakhs is making a huge difference.
Yes.
So there must be something else for that.
Well, that is the difference. The
You can
reason is this.
understand,
But the
this
reason is
brokerage
this.
is also 80 lakhs is getting out of this
No,
transaction.
but the reason is this, maybe. Not the reason is the proclamation will be made by the recovery officer.
Hmm.
He is appointed only to, because the trading only in the market. But Lordship knows this is share trading is not a very big issue at all. The shares on the date, they will see the chart at the board. What is the market value as on that date? And that share will be offered for sale because they are the brokers. And immediately it will be sold within no time. If the purchaser are there, but they will fix the minimum price. This is the
According
minimum
to the
price.
recovery officer, what are the expenses? Why? What is the how?
Only, my lord, that the proclamation of sale published in the newspapers. Nothing else.
And other for selling this,
Tax,
third
tax,
respondent is
GST
getting
and
the
other things
brokerage.
we will pay. But tax, GST and other things will be separately, it will be deducted and be paid by the, out of the sale proceeds by the recovery officer.
So there is no law on this.
No law on this. And he has collected from, another thing is, Lordship may kindly say, page 40, this rule, the income tax certificate proceedings rules says, rules 57. Rule 57, income tax certificate proceedings rules. Rule 57 reads this. Levy and scale of poundage fees. In respect of.
Take that.
Yeah. Downloaded version is here.
Rule?
Rule 57. In respect of any sale made in the execution of certificate, there shall be levied a fee by way of poundage on the gross amount realized by the sale, calculated at the rate of 2% on such gross amount up to rupees 1,000 and the rate of 1% on the excess of such gross amount over 1,000. 1,000 is the minimum, but that is only 2%. But remaining 1% has to pay. But the next one, Malad, there is a slab is also provided. That may not be unless.
This pound, what is poundage is not defined anywhere.
No, nowhere it is defined. And 4 may kindly be seen. 57(4). The poundage fee under sub rule 1 shall be paid by the purchaser of the property as soon as the sale is completed. But the reason why is this is not necessarily the shares only. Suppose it is immovable properties, some other immovable properties. If the recovery officer is incapable of selling those immovable properties somewhere different places in India or abroad, so many things will be there. So in such circumstances, if it is entrusted to a broker or an auctioneer, then he is entitled to collect the poundage fees because he has to spend a lot of money for transportation and going abroad or some other places and auctioning of the properties. It will incur a lot of that is the reason why this percentage is provided, but not through the court. Suppose, my lord, even under Order 21 Rule 76 of CPC, this provision is there. Please see there also, if Order 21, there is a parameteria with this Rule 46. He can entrust to the broker and they can sell the property. There is nothing where.
No, you will pay that amount. You will pay that amount as per the
brokerage charges has already been paid.
No. As per the order of the recovery officer. Yes. What you would be doing with that?
Which one? Amount. Nothing, my lord, that will go to the central government fund, that's all, nothing else. Suppose if they collect it, it has to go to the central government fund. Because recovery officer under the,
Negotiable instruments and shares
yes,
in
please,
corporations.
they- the same, just.
If the property to be
Yes.
sold is a negotiable instrument or a share in a corporation, the court may,
Yes.
instead of directing the sale to be made by public auction, authorize the sale of, same, like how it
Yes,
is in the income
same
tax.
rule 46,
46.
reproduction of rule 46, as parameter with that. So therefore, my respectful.
So your submission is that poundage fees is not required to be paid.
Yes, and that apart, Vilash may kindly see, the demand notice itself is very clear. We are incapable of identifying the purchaser, therefore you pay. That is impermissible. But another thing is, my lord, even the appointment order, Vilash may kindly see, they have appointed, the recovery officer has appointed the broker, third respondent. In the appointment order also, or it was not intimated to the Canara Securities, you must collect the brokerage, poundage fee from the purchaser. Because rule 57(4) says, amount has to be collected from the purchaser.
No, in selling the shares, where is the question of poundage?
That's right. That is my.
Why the purchaser will pay that?
Correct.
General,
That's right.
general
Because
transaction of
ultimately
shares.
it is in the platform of the stock exchange, they will purchase it.
Whatever the rules applicable
Yes,
there, he will do it.
GST and other things, they will pay it off. ST, that is also taxes also paid. Therefore, my respectful submission, it is impermissible, is my.
Yes.
Then there is one
That's-
very old
that's-
judgment, but not on the exactly on the point, no other judgment. But this is what is
Take that.
poundage? What is poundage fee? That is a. Please, your last kindly, this is the case where the judgment debtors sought permission of the court to sell the properties, through private auction. Under Order 21 Rule 83, under Order 21 Rule 83, a judgment debtor can seek permission of the court, sell the properties and realize the amount and pay the amount to the debtor, creditor. This is what they have done. In this, para 6 may kindly be seen.
Poundage is a fee charged by the court for the services rendered by it.
Vilash may kindly come to page para 7.
That's what I'm looking at.
Yes, the poundage fee is charged by the court for the services rendered by it. It was pointed out in so and so case, poundage is the fee which is levied in England by the sheriff as the remuneration for the service in this country, as the officers of the court conducting the sale are paid.
Who appears
a
with third
fixed-
respondent?
Third respondent.
Third?
Mr. Muttanna was appearing. They have filed a statement also, my lord.
Yes, for the councils.
Lordships, I appear for respondent number 1 and 2.
Yes.
My lords, I
What
have
do you
been
say?
directed to take notice few weeks ago, my lord, though it is WPS of the year 2020. Now the files have been transferred to DRT Chennai pursuant to the notification of 100 crores and above. I need some time, madam. I have to place it on record with the instructions. Only a few weeks back, I was directed to take notice. Accordingly, I have requested to send the instructions. Could it be maybe treated as part-time, madam, and posted for some date?
Why was the court hearing it for such a long time if it is adjournment? You should have asked it at the beginning.
Your lordship, my learned senior comments also, I thought my lordship would maybe treat as a part-time, maybe posted for some date. I will place on record with the instructions.
Parted, when can you file your objections?
My lord, sir, now another few, I think 1 or 2 weeks time is required, maybe taken up immediately after.
This is matter as parted after vacation.
Please.
Yes, some date may be fixed, your lordship, so I will place it on record. I understand the issue involved in it.
Come on, 10th of June.
Please.
Obliged,
Yes.
deeply obliged, deeply obliged.
No mentionings now. No mentionings now.
Madam, court officer. Court officer, madam.
ಹೇಳಿ ಮೇಡಮ್.
Serial number 17 ಅಲ್ಲಿ serial number 17 interim order extension ಆಗಿದೆಯಾ? ಮೇಡಮ್ ಹೇಳಿದ್ರು ಅಯ್ಯೋ ಎಲ್ಲೆಲ್ಲ ಇದೆ
ಅದ್ರಲ್ಲಿ
extend
ನೀವು ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳಿದ್ದೀರಾ?
ಅಲ್ಲ ಎಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರು ಅದಕ್ಕೆ.
ಅಲ್ಲ ಮೇಡಮ್, ವೆನ್ ಇಟ್ ಈಸ್ ಇಫ್ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಅಲ್ಲಿ ಅದು ಇಯರ್ ಆಗ್ದಲೆ ರೀಚ್ ಆಗ್ದಲೆ ಅರ್ಜೆಂಟ್ ಆದ್ರೆ ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್
ಇಲ್ಲ ಇಲ್ಲ ಲಾಸ್ಟ್ ಕ್ವೆಶ್ಚನ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ. ಲಾಸ್ಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ
ಸ್ಟೆನೋಗ್ರಾಫರ್ ನೋಡಿ ಮಾಡ್ತಾರೆ. ಸ್ಟೆನೋಗ್ರಾಫರ್ಸ್ ನೋಡಿ ಮಾಡ್ತಾರೆ ಮೇಡಮ್.
ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತಾರ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾ ಇಲ್ಲ?
ನೀವು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ 2:30 ಮಾಡ್ತೀವಿ ಅದಕ್ಕೆ.
ಮೇಡಮ್ ಇಟ್ ಈಸ್ ಮ್ಯಾಟರ್ ಮುಗ್ದೋಗಿದೆ ಅದು. ಸ್ಟೆನೋಗ್ರಾಫರ್ ಹೊಟ್ಟೋಗಿದೆ ನಿಮ್ ಫೈಲು.
ಅದೇ
ರೀಚ್
ಎಂಟ್ರಿ
ಆದಾಗ್ಲೇ
ಮಾಡಲ್ ಹಲೋ
ಸರ್ 2:30 ಮ್ಯಾಟ್ರು ಹೋಗಿದೆಯಂತೆ ಬೋರ್ಡ್ಗೆ ನೋಡಿ ಸರ್. ನೀವೇ ನೆನ್ನೆ ಸೈನ್ ಮಾಡಿಸ್ಕೊಂಡು ಎಲ್ಲಿಟ್ರೆ? ನೋಡಿ ಅದು ಇಯರ್ ಎಂಡಿಂಗ್ ಅಲ್ಲೇ ಮೆನ್ಷನ್ ಮಾಡಿರ್ತಾರೆ ಸರ್. No one absent last time. ಸರ್ 230 ಮ್ಯಾಟ್ರ್ ಇದೆ ಸರ್. ಕೆವಿ ಲೊಕೇಶನ್ ಇದೆ ಇದರಲ್ಲಿ. ರಂಜನ್ ಕೇಳ್ಕಾರ ಬಟ್ ಅವ್ರ ನೇಮ್ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಹೌದಾ ಸರ್ ನಿಮ್ ಮ್ಯಾಟ್ರ್ ಒಂದು 230ಗೆ ಲಿಸ್ಟ್ ಆಗಿದೆ.
Yes, madam. Appearing through
ಅದೇ
VC, madam.
ಡೇಟ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಮಿಸ್ಡ್ ಔಟ್ ಮ್ಯಾಟರ್.
Yes, madam. I am present.
ಓಕೆ.
The first thing is that I don't want any mentionings at this 230. Let your colleague be there or somebody mention it. Have you informed the other side? Does this matter at the request of non-counsel the petitioner? On 23rd?
Serial number 50.
This is what everybody will start.
Memo for withdrawal. Memo for.
Why are you moving it now? Morning you're supposed to do it. Do it in the morning, not now. Yes.
Matter at 2:30. For petitioner.
The petitioner, Lord. Lord, petitioner is present before the court. I'm filing an affidavit.
Where is Mr. Lokesh?
Anjan Kelkar is.
Lordship, I am
He's-
find permission to appear virtually, my lord.
Yes. No, the cause list reflecting the name of Mr. Lokesh. You filed wakalat?
Myself, yes, my lordship. File wakalat, myself is also.
Yes.
Initially, Lokesh appeared on his behalf
Yeah.
first day.
Have you seen this affidavit?
But I've sent him through WhatsApp. In fact,
Have you seen it? Affidavit.
No, not yet, my lordship.
No, he says he has sent it to you.
WhatsApp.
What they are saying is,
Yes.
they will undertake to, they undertake to pay 5 lakhs within 1 month from today.
Yes,
Within
ma'am.
1 month from today is, that's by 16th, that is 15th of May. And the
remaining-
clear entire loan amount within 6 months. That is another 5 months from there on.
My lordship, 6 months duration is too long. Any even
This
otherwise
duration is
also.
on the higher side. It should be, everything should be concluded within 4 months.
My lord, I'll do one thing. 5 lakhs, my lord, I'll deposit even.
That's what
before
I'm
Monday.
saying.
Please.
5 lakhs, 1 month,
Please.
remaining amount, another 3 months from there on. Because 6 months, even for big amounts also, I have never granted 6 months. Any other party is there,
Please,
change it and,
please, I'll.
please change it and then give it to,
Please,
then I'll pass on.
Please, please, kindly, sir.
Yes,
Yes,
grateful, my lord.
Oblige.
yes. After, yes. No, call the list.
Number 45. Cell number 45.
For the
Number
petitioner,
145.
petitioner counsel, my lord, request for a short accommodation is
HBL.
What is this? Oh, Senior Citizen Act. When it has come up? It has come up before me on 12/3. It is submitted as a single, no amendment is required with regard to the maintenance of the division has taken a contract and the one related appeal is pending. This is matter on so and so. This is matter. Finally, on 24th, no further time. Next, 46.
Cell number 46.
Who appears with the respondent?
Kalyanar. Sampannanavar.
Do that.
Basavaraj Sampannanavar.
Lord, this is a case of medical negligence. Proceedings were initiated by the medical counsel. My Lord, the impugned order is at annexure A.
He is the one, the advocate represents Medical Council of India.
Please, my Lord,
Sapanavar Basvaraj Shivappa.
represent. The
Yes.
medical counsel is represented, but the complainant is not remained absent.
To quash the impugned order dated, passed by respondent number 1 is Medical Council of India.
Medical counsel.
Where is that order?
My Lord, annexure A, page 19. my Lord.
Yes, let's read.
My Lord, may I read from page 20, my Lord? Allegations made in the complaint is capsulated. That on 16/9/2014 at about 9 AM, the wife of the complainant
No, the complainant is served but not represented.
Not represented.
Yes.
Complainant Srimati Lakshmi was admitted in Jayanagara Community Health Center, Mysuru for undergoing tubectomy at about 1 p.m. The doctors advised to take her to Jayadeva Cardiac Block situated within the premises of Care Hospital, Mysore, as she had developed high blood pressure and lost consciousness, and she was taken to the said hospital at 2 p.m. and she was declared dead at 4:30 p.m. and the said police inspector, basing on the postmortem report of Srimati Lakshmi, has referred to KMC to ascertain as to the medical negligence on the part of the respondents. In support of his case, the complainant has got himself examined. Since the complainant did fail to turn up to cross-examine the respondent 1 to 3, albeit the number of opportunities were given the cross-examination of respondent number 1 to 3 by the complainant was taken as nil. Now the KMC has to unroll upon the circumspect vision on the materials available as to whether there is a medical negligence on the part of the respondents. The finding is in para 6. The patient who was healthy, otherwise as per the report, was admitted to the hospital at 1 p.m. for tubectomy, and after the initial procedures of the operation suddenly became serious within a period of 2 to 3 hours. Hypovolemia and shock with blood-stained peritoneum indicates the injury to the abdominal cavity. The postmortem report clearly indicates injury to the inferior vena cava, which must have caused the bleeding, shock and hypovolemia. These facts are clear indication of negligence on the part of the respondent number 3. Respondent number 1 and 2 have tried their best to revive the patient, but in vain. There is a medical negligence on the part of the respondent number 3, which has caused injury to the inferior vena cava, leading to the hemorrhage, hypovolemia and shock, and ultimately death. Hence, in view of the findings given, my lord, the complainant does not make any allegation against any of the doctors. He just gives a complaint, requisition to the police. After conducting postmortem, kindly hand over the body. I do not have any complaints against anyone. Subsequently, a postmortem report was given by the doctor. Based on the postmortem report, the police inspector writes a letter to the KMC for the death audit report. The KMC gives a reply saying that we cannot give death audit report. If a complaint is lodged, we will conduct inquiry and will pass appropriate order. That is what the KMC says. Below, what is required by the KMC to do is to record evidence, and based on the...
See the procedure.
Please, my lord.
What is the procedure contemplated?
My lord, procedure contemplated, my lord, as to exactly does not say under section 16, the medical counsel should be treated as a civil court for the purpose of summoning witnesses.
So we'll look at the provision.
Please. This is Karnataka Medical Registration.
Have a copy of it?
I have only one, my lord. I'll pass on.
Book is not there. You should ask the librarian. You were not heard.
Please, my lord.
You were not heard.
My lord, I appeared before the medical council. My lord, I have also filed my evidence affidavit.
Where is it all discussed?
There is not even a reference to my evidence affidavit. And also, there are two other experts, one doctor who had treated the deceased was also examined.
Just it appears the medical council, basing on the report, says that it is a medical negligence.
Miloda, to come to a medical negligence, what is required to be examined is the expert should give an opinion. This is a laparoscopic surgery done by a general surgeon who has taken training or certificate course in laparoscopic surgery. a person having equivalent qualification or higher qualification than that of the respondent number 3 should have been examined to ascertain the kind of negligence. My lord, in medical negligence cases, if for example, if a surgery is done, general surgery cases is done by a person having only graduation, that is MBBS, then it is a clear case of medical negligence. Here is a case where the surgeon has, while initiating surgery, he is required to do certain procedures. If he fails to follow certain procedures, then that could lead to a medical negligence, where it is a mandatory requirement of the procedure. Nothing is recorded here.
Adil and counsel for the petitioner in part, the respondent counsel appearing to the medical council. There is no representation on behalf of the medical council, Karnataka Medical Council. There's this matter on 27th. If on the day, if there is no representation on the day, the matter will, the arguments of the counsel for the petition, the orders will be passed.
The records have not been summoned from the medical council.
Variously, first of all, you should be
Please,
aware.
they have not even filed statement of objection.
No, first of all, forget about the records. They say that under section 17, any order passed by any inquiry and the order passed, it's like a judicial order or an inquiry. The order should speak about what is it, how they have come to the conclusion. Yes,
And the complaint was based on the postmortem report. If they were supposed to only refer to the postmortem report and say that it is a case of negligence, that clearly shows that prima facie they have not even conducted inquiry. There is no application.
Yes, next.
Please.
Bill number 47, Sunil Shastri M for petitioner.
Interim order.
Interim order only granted is extended.
My lord, be pleased to give a short pass over, my lord. Senior is arguing in quota number 1, my lord, he will be coming. Pass over.
When again passover is called, if there is no representation, I will, without even posting for dismissal, I will dismiss it. Today itself. Yes, passover. Next.
48, Rahul S. Reddy.
Just give the file.
Lords, a request for a short accommodation, my lords, on Tuesday, Lordship may have it.
This matter.
My lords, we have
I
engaged
think
senior counsel, my
you
lords.
can't take the court very.
My lords, they've already given
the
for
matter came up
translation.
on 1/4/2026.
My lords,
This
pass
court
over, my
made
lords.
it clear that no further adjournments will be granted. And in spite of that, the same is reflected in the cause list. In spite of that, a request, again today the request is made seeking adjournment. This court is not inclined to grant adjournment. Accordingly, the writ petition is dismissed.
My lords, I request for a pass over, my lords.
Yes, pass over, ask him to come.
Grateful.
Bill number 49, Shivaram S. for petitioner.
This matter came up before the court on 26/3/2026 and on 15/4/2026. On 15/4/2026, 15/4/2026. And the matter was directly listed on today. No further adjournments will be granted. Today, there is no representation. List this matter for dismissal tomorrow. Yes, 50.
Bill number 50. Bill number 50.
I'm for the petition, your lordship, in 50.2, your lordship. Your lordship, I have filed 2 IA, your lordship. I have filed 2 IA today morning, your lordship.
I'll consider one after the other. Let's take 50 first.
All 3 matters are same notification that are challenged. The petitioners and the properties are different. But some matters concerned the presence of PPID. So challenging the freedom of notification would not be allowed. Petitioner would not say it's not maintainable if you watch discretion about. But foreign benches have taken a view. Still there are alternative remedy. It is not a matter to be entertained. In as much as what all options and opportunities, your one judgment.
Take that.
Some similar freedom notifications in fact, in some of these matters, a section 5 to petition is also being filed.
Because the stay may not, we have sought the liberty of deleting these petitioners from the proceedings there. Otherwise, we not such a type of petition. So instead of keeping the matter pending here, the matters could be disposed of before the onward special court. The last kindly take the note. Page number 2, foot of the page.
Page number?
Page number 2 of the order. Foot of the page. This Petitions filed Article 226 and 227 of the Constitution of India. Related to the facts of so wide edition A and section 3 clause 2 of the Karnataka Protection of Interest of so Act. The very same, the dates are different, but the 3-2 notification is challenged before your office. So my submission is not to
Come to this order. Where is the finding?
Would not come to specific statement for 20 this would be from the all the discussion at page number 20 method. Harassment. This court has consistently taken the view that there is always generally available demands that are not based on the Constitution and the Constitution.
Let's look at the act.
Section 3 clause 2, which is challenged for your process. Section 3 clause 2. Notwithstanding anything contained in any other law or binding in force, based so much or based on market intelligence, reports or amount of gain received from any depositors or otherwise, the Secretary to Government Revenue Department is satisfied that any financial transaction is paid for A, B, C members. Where the government has a reason to believe that any financial establishment is actually represented to the interest of the depositors and intention to be brought their cause. See, I will speak all those about Fundamental paragraph after section 2 members. The government may in order to protect the interests of the depositors of such financial establishments after recording reasons in writing issue an order by publishing it in the official gazette attaching the money or property believed to have been acquired by such financial establishment either its own name or in the name of any other person from and out of the deposits selected by the financial establishment and where it transpires that such money or other property is not available for attachment or not issued for the repayment of the deposits such as the property of the state financial establishments or the person such as the promoters, partners, directors, managers or members of any other person of the state financial establishment. The government shall also notify the act in order made under section 2 in the official gazette and 2 other newspapers. So we also refer to section 5 clause 2.
Yes.
Section 5 clause 2, competent authority. The competent authority shall within 30 days from the date of receipt of the order made with section 3 apply to the special court for further order of attachment and action. Once the government issues the attachment, I have to file a petition to the honorable special court within 30 days from the date of receipt with the 5 laws. And the honorable special court, before any such a petition is filed, we issue notice to the objectors or the person is who issued the law.
No, in respect of this notification, what is the stage now?
Section, in some other matters like the petitions are not involved, right? The orders have been passed, properties have been made absolute. But section 5 petition also is filed in some of the petitions before this honorable court. But because this honorable court will also find this petition out of the state, but we have withdrawn the proceeding as far as the petitioners are concerned. So
No, the alternative remedy is under section that you have filed.
No, it's not there because of the order of this honorable court, I am not state and again put to the honorable court. So the right to file a fresh petition. Once you have a petition is filed, the petitioners here for respondents there, who is the respondents there, will be given an opportunity to file. They can say so to why the act attachment should not be made absolute and why the petition.
Let's see where is and before the competent authority, what is the procedure?
Please, Section 12 minutes, Section 5 2 minutes, is the procedural activities. I shall have to approach the honorable special court with the file petition praying that the administrative attachment made by the government of the thing to be made absolute. So once I approach the honorable special court, Section 12 may not be fairly considered.
Yes.
All of special court regarding attachment. Upon receipt of an application Section 5, the one which I read out to my last number, the special court shall issue to the financial establishment and to any other person in whose property is attached to the designated property of deed a notice accompanied by the copies of the application and affidavit and of the record of evidence, if any, calling upon them to show cause on or before a date specified in the.
Yes.
Right.
Yes, yes.
Your notice is not issued.
Yes.
The law also does provide for that. If no notice is issued, then they can approach the honorable court to make the objection. So this petition is nothing but a short circuiting of the entire statutory process for
Yes. Yes, Mr. Senior Counsel.
Yes, Section 3, where we see with regard to attachment, they will have to pass a reasoned order justifying the reasons for attachment. Kindly see Section 3. Unless this provision is complied with, the question of going to the next section, next stage will not arise. This is the view taken by our court. Kindly see Section 3. The government or the district magistrate in the respective jurisdiction, suo motu or on receipt of any complaint may cause the investigation of a complaint or fraudulent transaction referred to in this section. The district magistrate shall forward the report together with the complaint to the government at the earliest. Here there is no report by the district magistrate. Notwithstanding anything contained in any other law for the time being in force, whereupon complaint received from any depositors or otherwise, the government is satisfied that any financial establishment has failed. This is important. Financial establishment only has failed to return the deposit after maturity or on demand by depositor, or to pay interest or other assured benefit, or to provide the service against such deposit, or where the government has reason to believe that any financial establishment is acting in and detrimental to the interest of the depositors with an intention to defraud them, or where the government is satisfied that such financial establishment is not likely to return the deposit or make payment of interest or other benefits assured or to provide the services against which the deposit is received, government may, in order to protect the interest of the depositors of such financial establishment, after recording reasons in writing, issue an order by publishing in the official gazette attaching the money or property believed to have been acquired by such financial establishment, either in its own name or in the name of any other person from and out of the deposits collected by financial establishment, and where it transpired that such money or other property is not available for attachment or not sufficient for the repayment of the deposit, such other property of the said financial establishment or the personal assets of the promoters, from partners, directors, managers or members or any other person of the said financial establishment. Government shall also notify the ad interim order made under subsection 2 in the official gazette, and 2 newspapers having wide circulation shall cause to be affixed a copy of such order on some conspicuous place. So it requires that it is only where the financial establishment is concerned this order can be passed. Now here is a case, my lord, where the petitioner is concerned is a depositor. Kindly see, my lord, the page 16. I have given the amount of deposit which I have made with the financial establishment. Lord, kindly take, our petition is 50.1, that is WP 1111 of 2020. The other 2 cases, my lord, are slightly different. Our case is.
So let's see only if you're arguing 50.1, we will.
I'm only respect.
Yes, 50.1 we'll look into.
Lord, at page 16 of my writ petition.
What is the name of the petitioner?
That is the petitioner
R.
is
Krishna.
Krishna, R. Krishna and another.
R. Krishna and
And Nisarga developers. Now these persons, my lord, made investment with the financial establishment at page 16. They had deposited certain money between 2010 to 2017 at page 16, the tabular column. 2010-11 we deposited 2 lakhs, No money was given, that was a loss of net profit.
No, you're referring to page number 60.
16.
Page 16 of the writ petition, 16. In the writ petition, page 16 of the writ petition. In the writ petition, paragraph 5 of the writ petition, in para 5.
Yes.
Para 5, in the next page, there is a table. In that table, Lord, it indicates the amount which I have deposited with the financial establishment and the returns I have secured. Now, total amount which was deposited is about 20.90 crores, about 55 total return. It comes to net profit is about 34 crores. And this is the interest which I have obtained from the deposit which I made. Now, I am the only depositor who is sought to be targeted in the impugned order. Kindly see page 76. Page 76.
That is the financial intelligence report.
The report of the
Superintendent SP Financial Intelligence.
The financial intelligence, page 76.
78.
76 is the report given by the Superintendent of Police Financial Intelligence Unit. At page 79, at page 78, second bullet point.
Yes.
Page 78. After earlier profit returns, Your Lordship got it.
Yes.
Page 78. Brief facts of the case. Page 78.
There is 278 page numbers. Brief facts of the case.
Yes,
Earlier page is also numbered as 78.
Oh.
Yes.
Brief facts of the case, second bullet point.
Mm.
After earlier profit returns, complainant had discussed with A1 and A2 regarding future investment, decided to invest huge sum and invested around 11.74 crore rupees in the said Vikram investment in various dates from their personal accounts.
Before you further submit, now, according to you, there is an irregularity. They have failed to follow section 3. And with regard to all these things, these are on the merits of the matter, which will be decided eventually before the special court.
Unless they comply with this provision,
What is
the very
not
basis of provisional attachment itself is not there. Kindly see only one portion I will show. Page 191. Kindly see page 191, which is the order of attachment. This court has taken the view this cannot be passed casually. Page 191.
Yes.
Whereas upon the report of the investigation agency enforcement directorate after due investigation of the complaint of depositors, it has come to the notice of government by special officer of competent authority IMA. This is the basis on the basis of which the proceedings are initiated. This very basis, my lord, has been questioned before the Delhi High Court, and there is an interim order at page 185. This enforcement directorate.
What will happen is, even if you are not directly involved with that, and the money or the sale or whatever the proceeds of that or transfer, those properties will also be notified. They have the power to do it.
No, financial establishment, I am like any other depositor.
Correct.
I have received profit. Some people have not got back the deposit. I cannot be made responsible under section 3. It is only the financial establishment or their agent.
Yes, if that's the point, we'll only hear him on that.
No, but there, that prima facie satisfaction, if it is not there, kindly take the judgment of our High Court. On what ground the court can consider it?
No, your primary ground is that you are not a financial institution.
That there is no reason, material at all in this order. There has to be a basis for arriving at the reason to believe. There should be some prima facie material. They cannot, this is a matter which has a very far-reaching consequences. So therefore, there has to be some prima facie material on the basis of which they arrive at satisfaction. That should be recorded in the order.
No, this
That
is a,
procedure
this
they
is
have to
a-
follow.
This is the notification you are questioning at page number 191.
Yes.
Let us see further with regard to you, what is that it is stated?
Yes, KPID scam cases that the Vikram investment is involved in fraudulent transaction by clandestinely, illegally collecting deposits or money from the general public, and thereafter have failed to return the same either after maturity or on demand made by the depositors or complainants with promised interest and other assured benefits, hereby failed to render the services promised to them. Whereas it has further come to the notice of the government that Vikram investment and people associating with them have been acquiring lands, movable, immovable properties, cash and others from and out of the deposits or money so collected from the depositors or complainant, thereby deviating from the intended purpose of accepting the deposits or money. And whereas the government has reason to believe that the actions of Vikram investment and people associating with them are acting in and detrimental to the interest of the depositors or complainants whose intention was to defraud the innocent.
What is the relation between the
There is nothing
petitioner
in
and that?
respect of our case. There, only one point I'll just point out in this order only, page 220. There is no reference in this order, but whereas in the attached documents, kindly see page 220. That clause F.
Yes.
This is page 209 is the application they have made. In this order, there is no reference. 209 is the application which they have made where the allegation, let us see that also, because in this order, there is no reference to my case. From 209 is the application made by them before the City Civil Court. There at page 220, clause F. Properties at serial number 12, 13, 14, 15, 16 were purchased by respondent number 21 from out of the profits earned on his investments in respondent number 1 without any sort of legitimate business with respondent number 1 to justify huge profits of around 35 crore. The said profits were paid by respondent number 1 out of the funds received from other depositors without generating real profits from any bona fide business activity. This is only found in this application, not recorded anywhere in the order of the, there is no basis material on the basis of which they arrived at the satisfaction. In fact, this court has taken the view that while passing such an order of provisional attachment, there has to be material on the basis of which they arrived at that conclusion. That judgment may just refer to it. ILR 2010 Karnataka, page 328.
Yes.
Or in the compilation, page 16 of the memo.
Yes.
At page 29, ink page 29, or internal page 341 of the judgment.
Yes.
Thereafter, para 13, a perusal of the aforesaid provision makes it clear that the government or the district magistrate suo motu or on a complaint may cause the investigation of a complaint or fraudulent transaction. After such investigation, the district magistrate shall forward his report together with the complaint to the government. If the government is satisfied that any financial establishment as defined under the Act has failed in its obligation to the depositor or is acting detrimental to the interest of the depositor with an intention to defraud them, or is not likely to return the deposit or make payment of interest to the depositors, may issue an order attaching the money or property believed to be that of financial institution. The order of attachment passed under subsection 2 of section 3 of the Act have a legal effect should satisfy the following requirement. The order of attachment should be in writing. It should contain reasons for passing such an order of attachment. It should be published in the Gazette. It should be published in 2 newspapers having wide circulation. A copy of the order should be affixed on some conspicuous place of the property, so attached if it is immovable property. Properties which could be so attached under this provision are property acquired by financial institution out of the deposits collected by the financial establishment, property standing in its name, property believed to be acquired by such financial establishment in the name of any other person out of the deposits collected by the financial establishment, any other property standing in the name of financial establishment though not acquired out of the deposits collected by the financial establishment, personal assets of the promoters, partners, directors, managers, or members of any other person of the said financial establishment. This order of attachment is the nature of an ex parte ad interim order of attachment. Normally, the effect of an order of attachment is to convert an unsecured debt into a secured debt or to prevent alienation of the property attached during pendency of the proceeding. However, the order of attachment contemplated under this provision has the effect of divesting the owner of his property. Consequently, it vests in the competent authority appointed by the government. Therefore, this order of attachment results in serious consequences. Article 300A of the Constitution of India mandates that no person shall be deprived of his property save by authority of law. As the effect of such order of attachment a serious consequence of depriving the right of the owner in the said property, it is imperative that the procedure prescribed under law has to be strictly followed. Any violation of the procedure prescribed would render the order void, and consequently there would not be any vesting of the property in the competent authority by virtue of such void order. Therefore, in the impugned order, order of provisional attachment, there is absolutely no reason why my property should be attached. If it is, there is some satisfaction, some material, nothing prevents them to pass an order of attachment. Once again, that is a different issue. If there are valid reasons, I can go and seek for the raising of the attachment before the civil court. But they cannot casually pass an order of attachment and then say, go before the civil court seeking for the not to confirm the order of attachment. Well, it is our case. And the records also disclose, these are only cases, I am like any other depositor, I have realized my money. Others have not got the money. That is the only distinction. There is nothing to show that I am an agent of the financial establishment in any of this order.
Yes. With regard to section 3.
These are wise in terms of procedure of the three, because there is absolutely no recording of reasons in the attachment order. Identity attachment order is one submission. And second submission, what is either way, I'm not having anything to do with the financial establishment. The first submission may not be true for this reason. I'm having a handicap because the reasoning is Kannada. But that doesn't mean that there's no reasoning. You can also kindly see page number 199.
No, this notification.
It's indeed true that the main portion of the notification does not carry the reasons. It is also equally true that is an annexure along with that notification. And I will contend a lot that the annexure is a part of the notification.
Where is that?
At page number 199. Go to you should start from 194. 194 may not make any thing. 194 may not make the notification. 195 may not make anything. 195. The table, annexure 1. And now at 199, property value number 5 and 7 are the properties that belong to the petitioner. But the some substance
190?
199 belongs. 199.
What it stated here?
The reasoning that is given here is the reasoning that will be found in page number 128 and also that's found in my petition. In my petition, all that I've done is I've translated the reasoning given in 199. So the reasoning is correct on the Honorable Special Court will indeed consider. But to make a statement before the highest court in the state that there is absolutely no reasoning and only on that ground the notification has to go, may not be true. 199 is the answer. If I'm not so direct, I'll find it.
No, what is there at 199 is also there in that order.
In my complaint.
In your application before the.
Also also my lord, the same properties have also been attached by the ED, enforcement direct check under the provisions of PMLA. Now my lord, PMLA authorities, the ED authorities and DPD authorities, we have fought out the litigation and now the enforcement directorate has agreed that they will give up the properties attached by them in favor of KPIT so that the depositors can get the money. But the fact is, my lord, the same finding has been given by the PMLA authorities. Not that I'm relying very heavily on that, but the fact is that there is an element of reasoning. What is the element of reasoning? What stands to test? What will be followed in an appropriate forum. But my humble submission is that the argument number 1, there is absolutely no whisper of any reasoning. That is false as falsehood itself would be. But if my lordship so did, I find the translated version. But it's the same as has been found.
Then what about this 50.1?
This is 50.1.
No, 50. You 50? You are also on the same line?
I am for the petition.
No, your case is also that, like how the senior counsel has argued.
What I would have done is, but they could attach only the properties of Vikram investment. They could not
Huh?
attach, they could have attached the properties of Vikram investment. They could not attach my properties. All the properties are purchased prior to the company coming into existence itself. Therefore, took the.
No, you are questioning the, like on the merits of the matter, how it is bad, attachment is bad. No, you are not on the point that they failed to follow the procedure under section.
The procedure, 30 days they not followed the procedure.
What is that? No.
30 days they should have sought for attachment. And it does not say when they receive the order of attachment.
So please show in this serial number 50. Serial number 50.
They did not include me as a party at all. My property was not there.
This matter heard reserved.
Page 36, my lord.
This matter. Yes, what about this? Page number?
36, my lord. Annexure C. I was not a party at this. 26, page number 26. Annexure A. That I was not a party at all, my lord. I was not a party at all. How could they have attached my property, my lord? It was not for confirmation. Subsequently, they filed a petition and make me a party.
Where is the public, where is this order under section 3?
They say.
Page number?
2019.
Huh?
They say it is on 7/2/2019.
No, what is questioned before this court? Quash the proceedings and miscellaneous pending on the file of the. How can the writ petition be filed under? It is an appealable order.
No, madam, they have not followed the procedure. They did not file the petition in time. They did not include me as a party.
No, that's what. Why can't you assail it in an appeal?
But when they don't follow the procedure, why should I go for an appeal, madam? There are abuse of.
So, for example, criminal proceedings are initiated. They have failed to follow the procedure. Then for that, a writ petition will be filed.
The first petition itself, I have not made a party at all, madam. The filed petition, they don't make me a party.
No. When what you can question here, the same grounds you will raise it because then already an order is there by the court.
Now the petition has been dismissed as against me saying that they are not pressed.
Huh?
They are not pressed the petition as against me saying that the matter is pending in the High Court.
That's why you question this order. How can against this order you come to the High Court?
They dismiss the petition, my lord. They sought for dismissal.
Look at the provision. If any person agreed with the order passed in the miscellaneous, what is the remedy?
Well, that I agree, my lord, but when I came here, my lord, the proceedings were there as against me. Subsequently, petitions were dismissed, saying that the matter is pending in the High Court. The matter has been closed now. There is no matter at all against me now.
Is it so?
Yes, ma'am.
What happened now? There are several properties. Only some of the petitioners, some of them were came before this honorable court. But this honorable court will also kindly please to pass an order swaying in their favor. Now the lords, when the order has been stayed, when P2 notice has been stayed, if I get continued the proceedings until 5/2, I will be in cross contempt of court. So I must stay. So I sought the permission of the honorable court that only as far as the petitioners before the honorable High Court are concerned and their properties are concerned, the petition may be closed. It's so subject to the outcome of the petitions. So I cannot say that because the stay order was granted here, they have withdrawn. So now the matter has become functus officio, or the court has become functus officio, or that I have lost all rights. Subject to the outcome of this petition.
What is the appeal against the order of in this miscellaneous?
Section 16, Lords. Section 16.
Yes, go file an appeal.
There are no proceedings, my lord.
because I have obtained an order of stay, they got the petition dismissed as against me. They have withdrawn the petition, and they did not file the petition in, like, within 30 days, my lord.
No, no, as far as now, if even on that count also, if nothing is pending, what is to be decided now?
Procedure of the statutory provision has not been followed, that's why I commented to you. Also, 26.
And four, my lord, kindly allow this dismiss the petition. And when you give liberty to issue a fresh plea, fresh fight. I'll have to file a fresh fight. So since we have already withdrawn the petition, there's nothing on the card because of the stay order. So once my lord will dispose of this petition, liberty will be given to my lord's file a fresh fight. And they can contest the matter.
Again, subject to the hardship. Again, I have to undergo the hardship.
No, because you have to go to you have to go through the hardship. We can't decide something which we are not, which the High Court shouldn't go into all that. When there is, it's a special enactment, there is a provision under the Act. The writ petition is filed, seeking the following order, so following prayer. It is submitted that without it is a case of the petitioner that
There are no proceedings pending. I finally order of the Honorable Special Court. It can be found at page number 16 of the statement of objections. Plus the operating question cannot permit to be. I number so and so filed with the petition are allowed. The petitioner is permitted to leave the respondent numbers 8 to 26 and the respective properties from the petition with liberty to file a fresh petition against them after disposal of the respective petitions filed.
it is a case of the writ petitioner that
Such a thing is not contemplated at all.
the crime is registered against Mrs. Vikram Investments, in which the petitioner number 1 has been arraigned as an accused number 3. Though the FIR was registered way back in the year 2018, there was no investigation that is conducted by the jurisdictional police authorities. And the matter is still pending at the crime stage before the concerned magistrate. It is stated that it is a case that there are no allegations whatsoever against the petition number 1 in the complaint. In spite of the same, the respondents proceeded to pass a final order of attachment during the pendency of the proceedings. It is a case that the respondent number 2 in the petition filed before the court have admitted that the petitioners herein are one among the investors who invested in Mrs. Vikram Investments and without any application of mine, considering the facts and circumstances, arbitrarily passed an order attaching the properties of the petitioner number 1 and irrationally attached the properties of petitioner number 2 and 3, who are the family members of petitioner number 1. And the concern done by the petitioner number 2 establishes the arbitrariness in the action of the respondents. It is stated that the scheme of the Act provides for attachment of properties belong to the financial institution, either in its own name or in the name of any other person. But in the respondents have failed to even value the assets and liabilities, and the entire procedure that is undertaken by the respondents is contrary to law. It is also submitted that after the writ petition is filed and when after the interim order is granted by the court, the proceedings before the special court are closed with the liberty to the second respondent to initiate the fresh proceedings after the writ petition is disposed of by this court. it is submitted that as the respondents have failed to follow the procedure that made the petitioner to come before this court by filing the instant writ petition. The learned counsel appearing for the second respondent submits that as a writ petition is pending, the proceedings against the petitioner were closed, giving liberty to the second respondent to initiate the fresh proceedings when the writ petition is disposed of. It is submitted that under the act, when an order is passed by the in the miscellaneous petition, the remedy of the petitioner is to file an appeal. To file an appeal against that, but he cannot come before the court, cannot come before this court assigning the said order. It is submitted that when the statute provides an alternative remedy to the petitioner, he cannot file a writ petition under 226. It is submitted that as the proceedings are closed, the second respondent will again initiate fresh proceedings and issue a notice for fresh proceedings under 5.2. He will initiate the fresh proceedings under section 5.2 of the Karnataka money lend, the Karnataka 1 minute. Under the Karnataka Protection of Interest of Depositors in Financial Establishment Act 2004. The petitioner has questioned the proceedings in miscellaneous petition number 250 of 2022 on several grounds. When an order is passed in a miscellaneous petition, the remedy that's available to the party is, affected party is.
Because here there is no order passed because the proceedings are pending with us. What was submitted was not the proceedings. In fact, we should have sought a written permission.
To quash when the petitioner has filed this writ petition, to quash the proceedings in miscellaneous 250 of 2022, the 2022, on these ground, the grounds as extracted by this court. And in the light of the writ petition that's pending, now no proceedings of the miscellaneous petition 250 of 2022 as far as the petition is concerned has been closed. The petitioner has now as submitted with the learned counsel, the second respondent. The second respondent has initiated the proceedings under section 5.2 of the act. 5.2 of the.
Which has been stated by the Southern Report.
So now I'm saying, now you have to initiate the proceedings under section 5.2 of the act.
Granting liberty to them to file the. It opposed to granting liberty to them to file a fresh petition on the order.
No, that is what court has granted them. The trial court has already granted them that liberty. Once this writ petition is closed, that can be agitated by them. That is what is the order. What did you know? As per the liberty given to them by the court. Once this writ petition is disposed of, that they can initiate the fresh proceedings. In the considered opinion of the court, in the matters of this nature, all these questions, whatever the remedy lies before the special court, but not before the court. And if any order is passed by the special court, that can be questioned by filing an appeal, and they cannot come before the court in a writ petition, as all these disputed questions of fact cannot be decided by the court in a petition filed under 226. Accordingly, the writ petition is in the light of the fact that the miscellaneous petition number 250 of 2022 is disposed of, giving liberty to the second respondent. This writ petition is also disposed of, giving liberty to the second respondent to proceed in accordance with law.
All contentions will be kept. All contentions will be kept open.
All the contentions are kept
I have
open.
taken a stand, I'm only a depositor, I'm not involved in the.
All contentions are left open, and this court has not expressed any opinion on the merits of the matter. Then what about 50.2?
Your Lordship, I'm for the petitioner in this, Your Lordship. Today I have filed two IAs, Your Lordship. It needs to be put up and heard, Your Lordship. I have filed two IA. One is amendment and one is for calling of record. I've served it to other side, Your Lordship.
What is that IA?
IA for amendment of the additional ground, Your Lordship. It has to be put up, Your Lordship. I have already served it to the other side.
But no objection, the application will be allowed and the matter will be disposed of the same service.
Date may be fixed, Your Lordship.
No date.
Please.
All are connected matters.
The IA needs to be put up, Your Lordship. We have filed it today, Your Lordship.
IA number so and so. What are the two IAs?
My last permit with another copy will be served in this phone.
What is that?
The copy of the application. The copy of the application.
She was referring to two IAs.
The same one. They have sort of copy of me. And this is the code.
IA number. They're not even numbered.
No, Your Lordship. It was filed today morning, Your Lordship.
It is submitted that the IAs were filed by the, two IAs were filed by the petitioner. This is matter on 23rd, along with the IAs.
Your Lordship,
On
after
that day, the
26th, Your
petitioner-
Lordship, we have briefed senior counsel's daughter's wedding.
On that day, the petitioner shall advance arguments on the merits of the matter. Yes.
50.1 interim order may be continued.
That is
Lordship,
interim
interim
order
order
only
may be
granted is
extended.
extended, reserved,
50.1. Only 50.1.
only in 50.1.
Your Lordship, 50.2 interim order may be extended.
I mean, it's my word from another side, my friend. I will not see the matter will be considered before this order.
No, there is an interim order.
Isn't it?
Then we'll continue it.
I know, even if it's an interim order, I'll have to see.
50.2, lower list on 22nd. Yes, 51.
Number 51.
Yes, what happened to this?
Then number 51.
And he has paid first year
10 lakhs.
Why you charge that second year? Service. Will be permitted to provide.
Take that.
Usually policy.
Give him, you also served him?
Policy, leasing policy, where this all the conditions are notified while accepting the tender.
No, let's not go into that. You just tell, now, whatever the amount you are collecting, it's for a year.
Yes, sir.
It is for a year.
It is for the year. The auction took place in the year of September. He had paid.
Give the dates, give the dates. When was the auction?
The fishing right is started from 1/7/2022 to 36/2027 mother. There is the 5 years period mother. That financial bid was opened on 17/9/2022 mother. 17 September 2022 mother. There are the 14 participants in the for the auction mother, tender mother. Among them mother, this petitioner is the highest bidder mother. EMD was deposited 2,10,000 mother. After that mother, this petitioner has deposited 12,53,111 mother. He has total deposit 10,43,1100 or 46,333 mother. This is the for the year of 2022-23 mother. First period mother. They have not issued work order mother. Subsequently mother, without issuing the work order for the 22-23 mother, they have issued a next year demand notice to deposit further deposit amount of 13 lakh mother. So we have questioned the annexure D. Without issuing the previous work order mother, how can you issue demand notice for the next period mother? I have not exercised fishing right for the 2022-23 mother. On previous date I hearing that the respondent produced along with memo that the work order has been issued on 27/3/2023. Your Lordship may kindly see that work order, the date is mentioned as 27/3/2023, but it was signed that on 28/3/2023 mother. It was posted to the petitioner on 27/4/2023 mother. After filing the writ petition,
anyhow, there is an order.
Please ma'am.
There is an order for 20, for the year 2022.
After lapse of 8 months, mal that they have issued the work order, mal that.
When you have received it?
That 28, mal that. 28 I have issued the 28/4/2023 I have issued the work order, mal that.
28/4/2023,
mal. I filed the writ petition, mal that on 12/4/2023, mal that.
Yes, now you please submit.
E-tender was done on 23/8/2022. As per the fishery policy approved this policy, the fishery year is considered as 1st July to 31st June. This is
What is
1st
that?
July to 31st June. This is the fishery year.
31st June.
31st June of the next year. 1st July.
1st July 2022.
2022. 31st June 2023.
No, when you call for the auction itself in the month of July, and when the amounts are paid, financial bid itself is opened on 17th September 2022.
Paid amount on 6/9/2022.
Hmm.
But it was notified that the fishery year itself will start from June to July. These conditions are notified in the e-tender.
So in this case, you have not given work order for him for the first year. Where did you give?
The moment we gave the amount on 6/9/2022, he is exercising the fishery rights. Till today he is exercising fishery
No,
rights.
ma'am. I am not exercising any fishing right, mal that. Because in the absence of work order, mal that, I cannot carry the fishing right, mal that. Your worship may kindly see previous date appearing the issued work order.
We are only, Mr. AG, we are only concerned with the first year.
First year our condition is
No.
According to him, he has received that the work order is received in the month of August 2023. That is already 23/24 has started by that time. So he is only concerned now. You have not given a work order for the year only 22/23. That's the only issue. After that, whether he is exercising or not is not the question that arises for.
participated in the tender and once he has paid the tender amount on 6/9/2022, his fishery rights were started. It was notified under the e-tender notification that fishery rights will start or commence from 1st July 22 to 31st June 2023. This is the year that he has to accept. This will be considered as a year under the fishing policy. Wait, is the fishing policy that which I have given.
Then what is the necessity of this work order? It is not required according to
It
you.
is required, my lord. It is required. We have issued it.
When he received it, when you have sent it,
It was sent
you
at
give
Your
it to
worship
him.
may kindly postal
To
receipt.
him.
posted on 27/4/2023.
Hmm.
So posted on 27.
So July, August, September, October, November, December, January, February, March, April. 10 months have gone.
This is not a, he is already notified that this fishery year is considered as from 1st July to 31st June only.
So he is left with, when you have posted it on 28th of, 27th of,
April, mal.
when did you receive on 28th?
28, mal.
So April is over, only is left with May and June. For that year, only May and June.
These are all the conditions that which are notified under the e-tender, having knowledge of
That it is notified.
That is so, madam, he has to challenge the conditions imposed under the e-tender notification. Now we cannot come and say that this was issued.
You are not, that is not the question I have asked. The question what I have asked is, work order to be issued to the petition is your responsibility. July to July, if according to you, for July to June is the fishing year, then till May, you have not given him. Only the work order, by the time you have given him the work order, for the first year, he is left with only 2 months.
But thereafter, even after 27/4, he started exercising the fishery rights on the pond.
His writ petition is only with regard to this.
So thereafter also, till today, he has not paid any amount.
They have not issued any demand notice, mal, the subsequent.
You are not exercising the.
No, mal, that. They have not issued any,
Can
I'm not exercising, mal, that. I'm not exercising any fishing right, mal, that. Because in the.
Will you file an affidavit?
Please,
Please
mal,
come. Land counsel for the petitioner submits that as there was no work order given to the petitioner, he has not exercised the fishing rights till now.
And
According to the, as per the instructions of the learned AGA, the petitioner has been exercising the fishing rights right from the beginning. The petitioner shall file an affidavit before this court whether he is exercising the fishing rights from 2022 till today or not. This is matter after vacation.
In 2 days back, that have issued endorsement that we have not issued any.
Earlier granted, it's extended in the next date of hearing.
Please,
Yes,
ma'am.
next.
The Lords, by an order dated 22/2026. Twenty-two, 2026, Your Lords. Respondent was
Counsel appearing
directed.
for the petitioner submits that only an amount of ₹5 lakhs to clear the loan. It is submitted, the same has been informed to the counsel of the respondent. His request,
The respondent should file a memo.
take that.
As on today. Lords, in the height on Monday, we will pay the entire amount due.
What is outstanding?
Out 5 lakhs.
The counsel for the respondent has placed it before the court,
Tuesday, Your Lords, please, Lords.
stating that an amount of ₹4,93,564 is outstanding. Land counsel for the petitioner submits that they are ready to pay the amount by Tuesday. Let's just matter on Tuesday.
Lords,
Yes.
53.
But appearing with the petitioner. The question involved in this petition is, my lord, whether the DRT has the right to condone the delay in filing the petition. But I have seen your lordship's order, my lord, your lordship has held that it has no right to condone the delay. But 2 other learned judges of this court, my lord,
But forget about my judgment. Look at the Supreme Court judgment.
so far, my lord, to my knowledge.
What is the judgment?
2
Other day that Vinayak, someone was referred to that judgment with regard to the limitation. Vinayak Swami or
2022, my lord.
not the 22, the latest judgment as well.
Bank of Baroda versus Orthodox become private.
Look at it.
I will.
The latest
But there are
judgment.
two judgments of this court. And my lord, there is a division bench judgment.
So now the division bench, nothing is liquid in the light of the Supreme Court judgment.
I will.
Look at it. Let's just matter on 23rd.
Murder.
Yes.
Then number
Murder,
24.
not on 23rd, person.
Then when?
27th.
Is 27th at the request of land counsel the petition. Yes, next.
Then number 54. 54. Jayalakshmi KB.
No representation. Tomorrow we'll take up. No representation for dismissal tomorrow. It's 55.
Then number 55.
Issued. Yes, this also no representation for dismissal tomorrow. Yes,
Then number
56.
56.
Appearing for the petitioners in this case, your lordship, kindly seeks an adjournment for 1 week, your lordship.
Why?
Your lordship senior is not in town, he is engaged in Tumkur, your lordship.
Senior citizen.
Senior citizen.
This is matter after vacation. It's 57.
That interim order may be.
Interim order earlier granted is extended. 57.
Then number 57. Vikram Munni, Rajgopal.
For the petition, my lords, it's connected to that serial number 5, my lords, which has been passed over, my lord. These are
But I
all
appear in serial number 5 for the respondent's counsel. But the point here is that none of these survive for the simple reason that may I just draw the court's attention to what is transpired. If the court is kind enough to take the cause list at serial number 5,
Passed over matter.
please, Mr. That was the reason morning Passover was sought, because there was this other connected matter as well. Please be kind enough to take the cause list. Serial number 5, the court is kind enough to see. There are about 4 writ petitions listed at serial number 4. May I first address the court on which each of these matters concern? All of them concern the same 2 parties. The company by name of Rajesh Exports and then Canara Bank. I appear for Canara Bank. Therefore, the respondent in serial number 5 in all the 4 matters. WP number 8603, that is listed at 5.1, is the first of the writ petitions filed by them, where they challenge the 13-2 notice. May I just give a 1-minute summary, and then possibly I can just take the court through the orders if the court permits me.
Yes.
Please, Bert. WP 8603 of 21 is the first of the matters. This is filed by them where they challenge the 13-2 order. Then comes WP 13136 of 21, where they challenge a petition filed by us before the NCLT for insolvency. Then comes 5.3, that is 16130 of 22, where they challenge a communication relating to willful default of proceedings.
One second.
I'm so sorry. I'm so sorry.
All these matters are relating to who has to pay what.
Huh?
Who has to pay what. Not, now the matter is really before the reality is in it. Not, they have already passed the order, and the final litigation with respect to the balance waiver, which is listed before the court on 24/4/2026 next week. If the matter is called after 24, not.
No. Whatever has to be decided by the DRT will decide.
That's
What
right.
What are the petitions before this court? That's what we have to look at. Now let's see. Straight away we'll take a WP number 8603.
I'm very grateful.
That's fine. So why should we keep it pending? Now, quashing the impugned notice dated 1/4/2021 issued by respondent number 2 under section 13(2). Who appears in this petition?
I am for the petitioner.
So why the 13(2) notice to be quashed?
The issue is related to whether the content of the demand notice or the statement or the balances which they arrive. The DRT has passed order on 18/2026, and the order basically provides that the reconciliation.
So you have already questioned these steps before the DRT.
That's right.
No, it is in the OA. They have initiated the OA proceeding. One of the issue was whether the bank has maintained the statement of accounts or the statements in the proper manner or not. We have submitted order.
No. When 13(2) notice is issued to you, why should you come to the court? Why can't you give a reply to them? Why should we look at?
In the meantime, I have deposited 77 crores considering the impact of the matter, before this honorable court. It was deposited in that matter. They were granted on 1/4/2000.
What is outstanding that you have deposited 77 crores?
Before this court, 77 crores in this matter.
I'm saying what is outstanding?
Outstanding was, as of that date, they claimed around 690 crores. The original OA claim was 790 crores. And till date, my lords, there are more than 800 crores are credited to their account from my account, various other payments. And in the meantime, my lords, DRT has secured their interest to the tune of 600 crores as per the order, separate order dated 10/1/2022. If they are in a hurry that there is something is going to happen, my lords, that the exigency doesn't arise. Because the property, even a single property, my lords.
No. How many forums you want?
Everything is get closed now.
No. If it is before DRT, fight it before DRT.
These are all the notices issued by them on their previous, my lords. I have made a payment. In fact, my lords, the serial
No. So whatever you are pleading here, won't it be decided by the DRT?
My lords, no, my lords.
Why?
So far as the willful defaulter is concerned, my lords.
This writ petition is not about the willful defaulter. This writ petition number 7887, 8603 is not about the willful defaulter.
It is about demand.
So that we need, it has no significance at this point of time. They have proceeded further. What is the significance of 13-2 notice now?
Today, your lordship dismisses this matter, then the question would say 77 crores. Where to go that 77 crores? So kindly have it on 24. I have deposited hundreds of crores, even in the 57 matter.
That's what, you have deposited hundreds of crores or you have deposited only 1 crore. What is the ultimate exercise and decision of this court?
Closure of all the matter. Now the DRT has arrived at a conclusion that their statement is incorrect, and they have also placed all the this latest order in the DRT.
No, for a 600 crores of outstanding, on 70 crores you take a stay of the proceedings when in 2021. Yes, list all these matters on.
Can I just make one short submission if the court permits me?
Yes. We'll take it up on 24th.
I'm very grateful. Can it be
25th?
25th? Grateful.
Yes, 25th. Saturday is a working day. Yes. List the matter on 28th. No,
Great.
that is, we will not wait for the DRT's.
No, the DRT has decided the issue raised by this court. I'll point out that also.
Shouldn't interfere in these kind of financial.
Absolutely. I'm very grateful. I'll point out. Grateful.
Huh? We'll see on that day. Yes, next. All the matters. Yes.
57, there's an interim order that.
Look at it, wherever there is interim order, continue. Yes.
58.
Lots may be delegated to DRT alerts there.
Huh?
Section 14 order was challenged, delegated to DRT alerts.
Yes, the writ petition is filed.
1 month.
Taking the following prayer.
4 weeks
The
time.
petitioner has an effective, the petitioner can avail has an alternative remedy before the DRT. Hence the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. Petitioner shall have the benefit of section 14 of the Limitation Act. The interim order that's granted by this court shall continue for a period of 4 weeks.
Much better.
Till number 59. 59 adjourned.
60 also adjourned.
60 also adjourned. Till number 61.
Appearing for respondent bank lordship.
For the petitioner.
Lordship, I kindly pray for a week's time, lordship. Senior is not in station, lordship.
Well, may I seek after vacation, my lord? They are not giving me anything.
This is matter after vacation.
Obliged.
Yes.
62. Till number 62.
Prayer,
Hanuman
interim order may
Tappa
be extended.
Look at it if it is there extra. Yes, 62.
My lord,
What is the date?
I'm for the petitioner, my lord.
After vacation it will come, yes.
My lord, on the previous occasion, this could direct the petitioner to file the affidavit. I filed the affidavit, my copy is stored on the other side to clear the debt within 4 months, my lord.
Where is that affidavit?
I filed, my lord.
Yes, Mr.
The 9th April, I filed the affidavit, my lord. Copy also stored on the Lord Council, appearing for respondent bank.
What is the outstanding amount? 24 lakh.
My lord, out of that, I paid the 12 lakhs, my lord.
Whatever is the outstanding, you will be paying in 4 lakhs, 4 months. Huh?
Affidavit failed, my lord. Affidavit.
What else we'll see? We'll give an interim order to him and we'll see. So that whenever he wants to pay, he'll pay. Anyhow, doesn't matter. Let him pay in 4 months. The writ petition is filed, seeing the following prayer. On the last occasion, the matter came up, Lencom submits that he is ready to pay the entire amount. And he'll come up with an undertaking affidavit. Today, an undertaking affidavit is filed before this court stating that that he'll pay the entire amount within 4 months from today. That is by August 16th. He'll be paying the entire amount in considering the undertaking affidavit filed before the court. This court, the learned counsel appearing for the respondent submits that the amount, if the petitioner is not the 4 months time that is sought for payment of the amount is on the highest side. And already the petitioner has got enough time. Next, having considered the undertaking of affidavit filed before the court, this court is passing the following order. The petition is disposed of, directing the petitioner to pay the entire amount as per the undertaking effort, entire outstanding amount as per the bank within 4 months, that is by 15th of August. In case the petitioner fails to pay the amount as per the undertaking placed before the court, he shall pay cost of rupees 1 lakh to the bank.
My lord, in the meanwhile, begging the bank to hand over the key of the house, my lord. They are key with the respondent bank, my lord.
After 4 months, they will do it. Once the amount is paid, the respondent shall deliver the portion of the property along with the other documents.
Great minutes.
Yes, next.
Cell number 62.1.
Where is 62.1?
All 3 months.
Same, yes, in all the matters, 62.1 and yes. Yes.
Cell number 63.
So I appear for petition, but seek for a week's time to file rejoinder, they have filed statement of objections.
What is the petition about?
Petition about to set aside ex parte order, I have filed miscellaneous.
Dated passed in I number.
While preferring miscellaneous, there was 37.
Rejoinder you require, you are questioning an order passed by the DRT. Neither he has to file objections nor your rejoinder is required. You have to argue basing on the order.
I'll argue next week.
No interim order.
No interim.
This is matter after vacation. Yes, next.
64. Finally.
All these matters next that tomorrow look at it as per
24.
all the old matters are there. Clear list. Yes.
24.
Yes, 66 and 67.
66. Cell number 66.
Fine. After vacation, 66 and 67. Yes, part-out matters.
Part-out matters. Cell number 68.
Yes.
Cell number 68. Arun Govindraj. Gautam Raghunath.
Yes.
My lord, I have. No, he's gone to pick up the books.
Yes.
My lord, I want to say this, my lord. One, if your lordship sees the impugned order, it seems to be that the learned judge is there saying that I'm.
Matters are listed for hearing it finally.
Yeah, finally.
Today there is no time, like there are so many matters. Some other day. Yes. Less this matters because if they were insisting for an interim order. Tomorrow I'll take.
Not tomorrow, my lord. Tuesday.
Tuesday. List the matters on Tuesday.
Thank you.
Yes,
My lord, there is.
Because he is not going home.
My lord, what is happening is
Moderate,
there is an arrest. If your lordship could keep it in abeyance till next day, till your lordship hears.
I've already extended all those benefits to this petitioner so many times. So now he is not entitled. That's the reason why I want to, even if you want the court to hear it tomorrow, I'm ready to pass.
No, please have it on Tuesday.
Tuesday. Yes. Yes, 70.
Cell number 69.
No, 69.
Cell number 69. CH Sudindra, petitioner.
I prefer the petitioner in this case, my lord.
Yes.
Lord, your lordship was pleased to grant visitation rights in the vacation of Dasara vacation. So now the summer vacations are. So we have made an application seeking visitation rights in summer vacation holidays so that we can spend some time.
Let this go before the
last
court.
occasion.
Is it a part-heard one?
Yes, ma'am.
I'll release it from part and let it go before the court.
No. Let a date be fixed. Let a date be fixed immediately after vacation. On that day, your lordship can dispose of the matter. So an interim order can be granted.
That? No, we are before the court only questioning an order that's passed by the court. Now, further every application can't be filed here. You have to file before the family, the
Lord, that
GNWC
after
court.
disposal of this matter, we can make an application. Now, since the matter is pending before your lordship. In the last occasion, Dasra vacation,
This will
similar
not
order, your lordship was
preclude
pleased to
you from
grant.
filing an application before the family court seeking custody.
Lord,
It's an independent application, independent adjudication, isn't it? It's only what is impugned before this court is some other order.
I agree. Keeping this matter pending, your lordship was pleased to grant us that benefit. So
Yeah, we will-
let
I'll-
this matter be
I'll
posted
post it before
immediately
the
after
court having
vacation.
also- Let the learned judge decide, delete this matter.
My lord, one submission. Let this matter be parted immediately after vacation. Your lordship may kindly fix the date. On that day, your lordship can dispose of this matter till such time, at least for a few days. Visitation rights may be given, and on 17th, there is a birthday of the child. We should also take part. So for that, a suitable order may be passed. Naturally, I am the father of the child.
What we will do is, please
I am the
understand.
father of the child.
What we will do is, tomorrow is the birthday. Let the father sometime exercise the visitation tomorrow. Please listen, exercise the visitation tomorrow. Let him celebrate the birthday. Let him spend an hour or two with the girl. 1 hour or 1 hour or 2 hours with the girl. And now I'm going to delete it from the part third.
No,
Let it go before the court. Let the court pass any order.
Lord, let this matter not be released from part third. Immediately after vacation, your lordship may fix up a date and this matter can be disposed of.
I'm only going to pass order as far as the birthday is concerned. No summer vacation I'm going to do.
Lord, vacation. Lord,
Please,
vacation is there. Similar order your lordship has passed in the past.
Only birthday I can, because it's tomorrow. Other summer vacation I'll not. It is submitted that the girl's birthday is tomorrow. Father wants to spend the time, considering the same. Tomorrow, what is the time?
Lord, morning till evening, let the visitation rights be given to us. In the evening, let them celebrate the way.
The father can spend 2 hours with the child.
Not 2 hours, my lord.
Between 10 and 12.
Not 10.
You can pick up
At
the
least,
child at 10 o'clock.
at least 4 o'clock.
Drop her back
Up to 4 o'clock.
1 o'clock. 1 o'clock. Drop her back at 1 o'clock. Delete this matter from the.
But that order may not be passed.
Huh?
That is not required. Immediately, your lordship may kindly have this.
Vacation. Yes.
But visitation rights so far as the vacation.
If you
My
want
lord,
that,
already
it will go before the other
the
court.
vacation, almost half of the vacation is already over. In remaining half, at least for some time, please.
This matter before the other court, before the court having the roster, delete from part third. Yes, next.
Let this application be considered before that court. A date may be fixed for that.
Matter, it is submitted that in view of the
24th or 25th, this matter can be.
Vacation. There is urgency in this matter. The history is directed to place before the court having roster on 23rd.
Please.
Yes, next.
Cell number 70 for dismissal matters. 70.
My lordship, I'm appealing for behalf of petitioner, my lordship.
You file a review and you don't appear before the court.
My lordship, I
Why?
held up in another court, my lordship. My senior is not available at that time.
Not only this matter, there are other matters of yours also, except for dismissal. What is this revision, review?
My lordship, is the insurance company matter, my lordship. A policy issued for the workman policy, my lordship.
This is passed by whom?
Justice Sanjay Koda, my lordship.
What is this?
My lordship, only interest part insurer is not liable to pay, my lordship.
As per the, it's a workman compensation.
Yes, my lordship.
Yes, who appears to the respondent? This has to go. Who was appearing that time? As per this,
My lordship, AC Balaraj, advocate for R1.
the name of so and so, list it on next Friday. Yes, next.
Oblige, my lordship.
Cell number 71.
Delete from the caption dismissal. Yes, 71.
For the petitioner.
In page 70.
Apologies, on the last occasion I was not present.
Yes.
And annexure A, my lord, is the RTI application. Respond number 2 submits to the PIO under the provisions of the RTI Act. Annexure A in the year 2013. The PIO at that time has given answer as per annexure B. Not the request for under annexure RA is in the year 2013, the request is made in relation to a complaint filed before the police station, Banchankari police station in 2006, which was closed in 2007. The answer, the response given in annexure B is that the complaint was never
What
registered.
is the order now?
Not the impugned order is not IM, who is a subsequent PIO, who came much later to the same post, have been directed, not have been penalized 10,000 rupees. First appeal is filed by the respondent number 2.
Why, where is this, where is Mr. Sharath Gowda? Even the other day also in some other matter, he was not there in this, then. If not alternative arrangements, everywhere he can't be there. This is matter. After vacation, delete from the caption, dismissal. Look at it, interim order is there,
Interim order is there, ma'am.
extended,
Great.
72.
Cell number 72. Cell number 72. Akash Rao.
Appearing for petitioner, madam. But one of the petitioner has been demised, and one of the petitioner has been demised, and we have not a proper instruction to
One of the petitioner,
is demised, my lord. He has been died, and he was the one who contacted us to file this, and we are trying to contact the other petitioner. If not, we will file a retirement memo in next 10 days, my lord.
the petition is not maintainable. Tumkur Grain Merchants Cooperative Bank.
10 days, my lord. So we will file.
The
This is a application.
petition is filed against Tumkur Grain Merchants Bank Limited. The petition is not maintainable. Then council submits that he'll get instructions. When
10 days.
is the matter on 28th.
Much.
Yes, next.
Cell
Delete
number
from the caption.
73.
Is 73.
73. Vivek Holla for petitioner.
Appearing for petitioner in 5214. This petition, both petitions were filed challenging the RBI master directions on fraud classification. I had both challenged the constitutionality of this circular as well as the notification declaring my account a fraudulent account. I'm covered by the judgment of the Honorable Supreme Court, which has read in the requirements of the principles of natural justice into the circular, and has held that for a valid declaration of fraud under the circular, principles of natural justice must be followed, a right of hearing must be afforded, and I've just tendered the judgment of the Honorable Supreme Court. Your Ladyship will see page number 48, ink page 48. The final directions of the Honorable Supreme Court are given. May I read?
No, where do you get that this particular circular is in question?
Please. At page 17 of the ink page 17, the civil appeals arise out of a challenge to the Reserve Bank of India frauds classification and reporting by commercial banks and select FIs directions 2016. So it was the same circular that I had challenged. Final directions of the Honorable Supreme Court are at page 48.
Opportunity of hearing to the borrowers before classifying their account.
Please. The Honorable Supreme Court holds that there are drastic civil consequences that result from a declaration of fraud because I am barred from availing further credit, my account's frozen, and investigation also initiated against me. Therefore, the Honorable Supreme Court has read in the requirement of a show cause notice and hearing into the circular, into the RBI circular, particularly at para 98.6 or 98.5 at page 49, the conclusions.
Yes, what do you say? Huh? So we'll set aside this and you please proceed in accordance with law by giving a reasonable opportunity to the petition. The writ petition is filed. Seeking the following prayer. Claim counsel for the petitioners of this particular issue with regard to the master directions on fraud classification and reportation bearing reference number. It's there in the prayer. Look at it. Dated so and so. Where there is no opportunity to the defaulter of hearing was find fault by the Honorable Apex Court. She had relied on the judgment of the Apex Court in case of State Bank of India and others versus Rajesh Agarwal and others, reported in 2023 6 SCC 1, wherein the Honorable Apex Court has held that the principles of natural justice demand that the borrower must be served a notice, given an opportunity to explain the conclusions of the forensic audit report, and be allowed to represent by the bank before their account is classified as fraud at the master directions on frauds. In addition, the decision classifying the borrower's account as fraudulent must be made by a reasoned order. Since the master directions on fraud do not expressly provide an opportunity of hearing to the borrowers before classifying their account as fraud, ad altrum patrum has to be read into the provision of the directions to save them from the vice of the arbitrariness in the light of the judgment of the Honorable Apex Court. The bank has to give an opportunity to the borrower before classifying the account as fraud under the master directions. In that view of the matter, the writ petition is allowed by setting aside the order dated 1/7/2016. The respondent are at liberty to initiate the fresh proceedings in accordance with law after giving reasonable opportunity of hearing to the concerned.
My lady, just one clarification. The 1/7/2017, that is this RBI master circular. In fact, the order declaring me a fraud has never been shared with me. Therefore, I don't know the date of that impugned notification. The order.
The proceedings that are initiated by the bank without issuing an opportunity to the petitioner cannot be sustained. Hence, the respondent bank shall initiate fresh proceedings in accordance with law. Yes.
Cell number 74, Sudhindra.
What about the next risk petition, 73.1?
Both are same. One of them is the company and the other is the directors of the company.
Same order.
73, my lords, is the company, 73.1 is the directors.
Yes. So the same order.
Same order.
73 is by the company. 73.1 is by the director of the company. Same, common order. Yes, next 74.
74.
Yes. Yes, 74. The writ petition is filed in the year 2022. And the matter came up on 15/4/2026 as there was no representation. The matter was directed to be listed today on the caption dismissal. Today also there is no representation. Accordingly, dismissed for non-prosecution. Yes, 75.
Cell number 75.
Challenges without a recovery, stated by the recovery officer. Without refiled version of application, that's the RDBI. And it was without recovery certificate as an issue. based on the recovery certificate, we have initiated the recovery proceedings before the recovery officer at DRT. That has been challenged before the Supreme Court. Section 30 of the RTD Act may not be very order passed by the recovery officer has to be challenged by the tribunal.
The petition is filed in the following prayer. As there is no representation on behalf of the petition the last occasion, the matter is actually listed today on the caption dismissal. Today also, there is no representation. When counsel apparent with the respondent bank submits that under section 30 alternative remedy. Under section 30 of the act, there is an alternative remedy. It appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution. Yes, 76.
Serial number 76.
For the petitioner,
Yes.
in this case, petitioners are the agreement holders under the respondent number 2 and 3.
This who appears for the respondent?
Annexure A sale agreement, registered sale agreement.
Your question and order passed under section 14.
Yes. Yes. I am not a borrower. I am not a borrower. I am a 1 minute agreement holder under the respondent number 2 and 3.
Who are the respondents?
2 is a container. He is a owner, landowner.
Pragati Cooperative Bank.
He is a bank minute. 2 and 3 minute landowners. My case is minute. You are last kindly minute. 8/2/2021. You are last minute. 8/2/2021. Registered the sale agreement in my favor. 8/2/2021.
Even if you are not a borrower, you can question it before the DRT. Again, it's this Pragati Cooperative Bank. You can't file a writ petition before this court. Please come. The writ petition is filed in the following prayer. The petition is questioning the proceedings initiated under section 14 of the Surface Act by the first respondent bank. The writ petition against the first respondent before this court is not maintainable in the light of the law laid down in Mr. Bharti's case. And that apart, the petitioner,
One makes
it is
submission.
agreed by the order
Yeah,
passed.
one decision, you are last. One decision.
Under section 14 of the Surface Act, the petitioner can approach the tribunal under section 17. The petitioner has relied on an order dated 26 September 2013. Wherein it is an order is passed stated that the petitioners who are the tenants cannot be dispossessed under the provisions of the Surface Act. A tenant who has been inducted into the premises has to be evicted under the due process of law. And accordingly, the order is set aside. This court is not in this court, in the light of the fact that the writ petition is not maintainable. This court is not going into the said aspect. The petitioner's remedy is to go before the DRT under section 17 of the Surface Act, though he is not a party to the, he is not a, neither is a borrower nor a guarantor. Anybody who is aggrieved can go before the DRT. Accordingly disposed of, giving liberty, section 14 of the, he shall have the benefit. Next.
Number 77.
Within 30 days, he shall go
77.
from the date of receipt of the copy. In all the matters, the 30 days limit. Yes, 77.
Aditya.
On 1/4/2026, 8/4/2026, no representation. Yes. Dismissed.
Serial number 78. Nayak NR.
On 16/2/2023, 9/4/2026. The matter came up only on 2 occasions before the court. On the 2 occasions, there is no representation, even when the matter is listed on the caption dismissal. There is no representation, accordingly dismissed. So non-prosecution is 79.
79.
Petitioner in this case.
Hmm?
Indian was not completed. You single one has not paid 100. Second, they have challenged the SA.
This matter, list tomorrow. Delete from the caption dismissal and list tomorrow.
Tuesday, my lord.
So I
Tomorrow I'll take up. Yes.
Sir, number 80, 80 disclosed, 81. 80 disclosed. 81.
They
Appearing for the
withdrawn.
petitioners, your lordship.
81.
But appearing for the petitioners, we got the instruction from the petitioner stating to withdraw the
A
petition.
memo is filed seeking to withdraw the writ petition. Accordingly dismissed as withdrawn. 82.
Much obliged.
Sir, number 82. 82.
Advocate for petitioner, my lordship. Lordship, one date could be because of senior has got high operation, my lordship, after the vacation.
Any of the writ petition is not maintainable against Repo Home Finance Company.
My lordship, here we are not the borrower, my lordship. That is the contest.
Whoever it is, you can go. What is that you are questioning? You are questioning.
My question
the-
is, my lordship, we are challenging the loan agreement and we are not the borrowers in this.
You are questioning the loan agreement. Why should
We
you
are challenging the loan agreement because loan agreement taken by someone and they came forth into peaceful position.
I've not ever seen a prayer like this. Writ of certiorari requires a loan account.
Yes, my lordship, because we are into the peaceful position, my lordship. In the March 2025, they came into
How can the loan
demand
account
notice.
be quashed? Ask your senior to come.
Please,
Let him tell the court what is this writ petition about. This is a matter on Wednesday. Under the same, delete from the caption, Wednesday.
My lordship, kindly give me on the next week, my lordship.
Next week, 23rd is next week.
83. Raju CN.
Only 22nd one I have to file affidavit. Parties are not 22nd.
Why you have not filed?
The parties are not.
And why you are not appeared before the court on the last occasion?
I appear, my lord. Lordship told me to file affidavit last year.
Under the same caption next week.
No, my lord, date, my lord, 22nd. 22nd.
Yes, 22nd under the same caption. Yes, next. Tomorrow, password matters tomorrow. List two.
Lordships kindly, my lord. The matter is posted for judgment for tomorrow, my lords. There is a serious urgency in this matter. The list one.
No time, no. We'll see,
My lord,
we'll see
one-
tomorrow.
My lord.
That matter, where yours is a Passover matter.
Yes.
That's why I said, you please
You're
argue, I'll pass orders. But you are not interested. Court has no time now, tomorrow.
My lord.
Yes.
My
one.
lord. 2:30, madam. David,
Huh?
parties.
Yes. Take that. Yes.
Yes, Lordship, I'm for the applicant, respondent bank. They've shared me the affidavit in that they have undertaken to pay the entire amount within 4 months as directed by the Honorable Court. My Lordship, in that the total outstanding they are going to close is 14,22,445. In the previous para, they have mentioned. My Lordship, since they are taking 4 months time, there will be an interest applicable on the loan because it's 4 months are being taken for repayment.
That
Yes.
will be.
My lord, one
The-
submission. Lord, section 14 application was filed on 11/2/2026. On that day, my lord, the due amount was shown as, my lord, 13,21,556.
But the difficulty is.
Within
we
1
can't
month, my
determine
lord,
all
1
that.
lakh amount, my lord, they have increased within 1 month. But now yesterday we have taken a loan statement. They have given a loan statement, my lord, what, 14,22,446.
In that case, you have to seek clarification from them.
Please.
You be satisfied with what is right or wrong.
Please.
Then we should record it. Party's presence is not required. This undertaking affidavit is sufficient.
Please.
So you please because I can't, the court can't go into those disputed
I understand,
questions. So you have to take the account from them, and if something is wrong, point out to them.
Please.
Now, what will happen is, whatever is the amount, and then from now onwards, till you pay the amount for the, maybe it will come in the month of August. August, whatever the interest that accrues, you have to pay. Better, I'll keep it like this.
Please, my lord.
You get clarification, we'll have
Please,
it on
Please, better.
23rd or 22nd?
23rd, my lord.
Yes, 23rd.
Please.
Yes.
My Lordship, one submission. If they are having any doubts on the amount outstanding, they can make a representation that will let the bank clarify. In the meanwhile,
Now
we'll
you
subject
do
to
it
that.
by the time.
Will be disposed of, Your Lordship.
And my lord, party presence.
Print the name of in that matter. Print the name of what's your name? Ranjan Kelkar. Print the name of Ranjan Kelkar. Delete the name of the other counsel.
So
Yes, number 2.
Party presence may be exempted on that day. Party presence may be exempted on that day.
Not required. In affidavit, all these undertaking
Please.
affidavits, we are not
Please,
asking for their presence.
Please.
Yes, 2.
Interim order may kindly.
Which number?
Interim order?
Kindly be
Earlier
extended.
granted is extended. S2,
Grateful.
Number 2, serial number 1. Petition number 1. Serial number 1 for orders. Dayamani.
tomorrow. S2,
Serial number 2. Serial number 2.
tomorrow.
Serial
What about 2?
2.
Lokada, yes, after vacation. 3,
Serial number 3.
what about 3? Yes, this also after vacation.
Serial number 4.
This
Petition
4,
number 4, my lord. I had given a representation, and since it was not considered, I am before lordship. Lord, since it,
tomorrow.
no paucity of time, lordship may direct me to file a fresh representation, then let them consider. I'm not pressing anything.
Tomorrow I'll pass
Please,
orders.
lordship.
Tomorrow 4, 5
My lords, I appear for the petitioner. I appear for the petitioner in this matter.
in 5.
Yes. My lords, no such records have been put. No.
Have the record? You have the
No,
record?
my
with
lords.
you?
My lords, that's not a judicial order.
It is there? Yes, let's this matter tomorrow. Have you served on them?
Please, my lords.
Yes. Any passwords?
Your lordship, serial number 27, the petition will become infectious, your lordship.
Which one?
See, list 1, serial number 27, your lordship.
What do you want the court to do?
Lordship.
No, I am raising
Sorry, my lordship.
tomorrow. Yes.
My lord,
Lordship
serial number 48, my lord. May I request for Tuesday, my lord? It was passed over. The translated copies are ready. I'll just get it ready on Tuesday. I'll
From today onwards, I'm going to, the cause list should indicate when whoever asks for a passover saying that the senior is appearing, and they would be paying cost for this. Every day, morning all passovers, afternoon full, the court is, with all these passover matters, it's, I can understand one day, but every day the same request.
I apologize, my lord. On Tuesday, my lord, we'll argue, my lord.
Just on Tuesday?
48.
And even I'm not your grant passover in this matter on Tuesday.
Yes, my lord.
Yes.
Interim order has to be extended, my lord.
Interim order only granted is extended.
Grateful, my lord.
We
What
have-
happened 12?
Serial number 12, my lord, that's a review matter, my lord. A review matter, they have not paid the maintenance for the past 13 years.
No, I have not granted any stay.
Hello,
This, the review, if it is pending here, you are not going to be affected by that.
What they're saying is they are filing a review petition and they, before the magistrate court, they say that they are blocking the arrest.
Tomorrow.
Tomorrow, my lord. Let the matter be taken up tomorrow, my lord. But there they have filed a memo.
I'll dismiss it today itself then.
Yes, please.
No, I heard. I'm convinced that there is no point. Tomorrow, yes. You have inconvenience. If it is a Passover, you have inconvenience tomorrow.
And and in the.
It's on Wednesday. What happened? 47 is passed over. Yes, that also, not Tuesday. We'll have it on Thursday. Yes, sir.
cancellation, free market